commence. Just a word about the timetable to start off with. I was hoping to get through the socioeconomic hearing and the policy hearing, hopefully before lunch, even if it's a bit of a late lunch. But, well, we'll do the socioeconomic hearing and we can review after that. The conditions hearing, I think Highland Council said that they would want Mr Buchan there. I guess Mr Buchan has gone home now. So I would imagine we would do that online, and we'll need to arrange a date for that. We can arrange a date in due course, but is next week a possibility, or is that online? Yeah. Perhaps we could do it on Thursday. Thursday would be free for me.
So I think because of my involvement here through the day and lack of internet connection, in the evening I've not been able to pick up my emails, but from the voice messages I have, my clerk's trying to get in touch with me urgently about next week. So I can't confirm definitely. Depends as well as to what the nature of the commitment is, because I could let this supersede whatever the other one is.
I don't think it'll be tremendously long, the conditions hearing. I think it's just it should be fairly, it shouldn't take more than a morning, I wouldn't have thought. If we did it on Thursday morning, Thursday the 3rd of July.
So I'll do my best without knowing just what the commitment is. If it involves appearing in court, then that might be different. But otherwise I'll feed myself from what else there is planned.
Can I put a kibosh on that? Sorry about that. Next Thursday morning I have a tribunal hearing, a virtual hearing before the Lands Tribunal, but which is starting at 10. It should be finished by 11. So I don't imagine conditions are going to take more than 2 hours. I would hope not. But
perhaps Thursday after lunch then.
Yes, sir. I have a consultation in my diary at the moment, but I can move that if necessary.
Sir, I have a personal commitment. I'm marrying off one of my daughters next week. I have to travel quite a long way to do it. So I can do Thursday morning, but not Thursday. I'm sorry, not Thursday afternoon.
Well, perhaps this is not the time to discuss it. Perhaps we can compare diaries, and I am free next week. The week after becomes more complicated. But if parties could compare their diaries and let me know a date that's agreed between them, or a couple of hours that's agreed between them, that would be good. Mr. Buchan will need to be there too, obviously.
Do you think a couple of hours, half a day?
I wouldn't have thought more than a couple of hours on the basis of what's been agreed so far.
So just to be clear, when we're phoning Mr. Buchan to find out his availability, could you do any day next week?
I think I would like to take Monday off. If necessary, I could do Monday, yes. So any day next week, yes.
Can I suggest Wednesday afternoon as a prime target? Just because I have quite a busy week next week.
Yeah, I can do Wednesday afternoon too.
I have to check because I don't know what I'm being phoned about.
But if when contact is being made with Mr. Buchan Wednesday afternoon would be.
And Mr. Fitzpatrick can make it too.
Taking him for granted, as I have all week, but yes, I'm glad he confirmed that.
Okay, and parties will also confirm availability for a hearing on ornithology, which I suggested from the beginning for second 2 weeks of August.
So perhaps I could just give notice to assist everybody in planning. Our ornithology witness is not available in September. She's got a long-standing holiday commitment in the first 2 weeks of September, but she could do August. August, yes.
think you said you were available in August, apart from a couple of days, Mr. Campbell. Yeah, that's good.
French.
Okay, so with that, we'll start the socio-economic hearing, hearing on the socio-economic effects of the proposed development.
Can I raise one matter with you first? You asked, after circulating a list of the places that you had been to.
Yes, please go ahead.
Which, thank you for that, that's very helpful. I have 2 proposed additions to your list. Would you like me to?
Of course, yeah, well,
offer those now, or send Mr. Kennedy an email with that?
Since I'm going to do the site inspections the weekend, it would be very...
The proposal is that you should, first of all, walk the first section of the core path into the Greshenish SLA, which I don't think is included in your list.
That would be the one from Greshenish Hotel rather than the top end. That would be, so if you drove to Greshenish Hotel and parked and then took the core path from there over towards Loch Dubaig, you get a lovely view of the existing Ben Aketil with the Coonan Mountains behind them on that path.
And that path is shown. Are you doing the light? No. And that core path is shown on Ms. Platt's map, is it? Good, right, I'll find it from that, that's fine.
So the second suggestion was that you... Now, Dr. Robinson will explain to you where he thinks you should go.
If you drive to Urig up the A87 and then take the road up the hill as if you were heading to the north of Skye, at the top there you can look back across Urig Harbour and you get a view of the Greshenish Peninsula and the turbines of the existing Ben Aketil. And then we'd suggest you just turn around and drive back in the direction of Portree down the A87 and you will enjoy numerous views of the existing wind farm and the landscape where they propose to build the new one on the way south in the direction of Portree. And that's the route that everybody coming from the Western Isles takes when they get off the ferry in Ulig, head south.
Good. Those are all the additions, are they? Yeah. Good. Okay, I'll do that.
So we haven't yet had the opportunity as a team to discuss, but I'll confirm before we break.
Right, so we'll proceed to the socio-economic hearing, and so taking part are Mr. Blackett from the applicant, Mr. Salt, Ski Boss Community Council, and Ms. McLeod. So I'd listed, I've set out another 7 items for us, another 6 items on the agenda after that. The first of which is the benefits of the proposed development. And the first question there is really just a confirmation. What I'd understood from your hearing statement, Mr. Blackett, was that all of paragraph 1310 of the EAR is incorrect. Is that correct?
Yes, that's correct. That should be disregarded. The correct numbers are summarised in paragraphs 3.2 and 3.3 of my hearing report. I guess I would also note that the benefits in the EIA in tables 1319 and 1324, that's the same numbers that are in those paragraphs in my hearing report, and that's what the assessment that's in the EIA chapter is based on. So we don't need to be concerned that the assessment is based on incorrect numbers.
Content with that, Ms. McLeod, I think you'd raised the point about the error in the figures.
Yeah, happy that it's now consistent.
Next question is another point raised by Ms. McLeod about the structural limits in Sky's economy. I think a number of objectors have raised this point, actually. Are there such limits that would restrict the degree to which you can benefit from, the temporary increase in economic activity associated with construction? For instance, is there benefit in terms of the accommodation required if there's already a high occupancy rate? Or are you ending up with just displacement? Can increased jobs be created on the island if there's presently little unemployment? Is it really people coming in from the outside? And can increased jobs be created if there's presently a shortage of housing?
Okay, I guess the short answer to your question is, are there limits that will mean the benefits are difficult to obtain? Is no, and I'll explain why. So in general terms, it can be said that every economy will have constraints that impact on their ability to benefit from a new opportunity, whether that's temporary or permanent. However, economies are not static, they adapt and to take account of these ebbs and flows, and given the scale of the temporary economic benefits here, which the reference to where they are summarised I made a moment ago, it will be expected that Skye and the wider Highlands should be easily adapt to realise these benefits. And I guess it should be noted as well that many of the employees who will be associated with this project will be employees of local companies. And those local companies are well used to finding ways of recruiting staff to facilitate their growth. Then I guess you made some specific examples though. One was on accommodation providers, and there is a high occupancy rate accommodation providers. I think as anyone who's tried to book accommodation for this evening will know, but it's not 100%. And as summarised in my hearing report and in the Glasgow Caledonian University report, which is the ACD 9.4, there are 2 million nights spent by tourists in the Skye economy each year. So the numbers we're talking about associated with temporary workers in the wind farm are insignificant as far as that's concerned, and wouldn't really show up in the figures. Then the second example you raised is about unemployment and vacancies. What I would say about that is unemployment and vacancies is not really a good measure of economic vibrancy. And I guess across the UK as a whole, unemployment is currently low, and many of the sectors of the economy are saying there are shortages in labour. However, the UK economy is not performing well, as is reflected in the UK government's setting economic growth as the number one priority. And so you might think, well, how do these things add up? And it's because a vibrant economy is one that can change over time. And some sectors will decline and new sectors will emerge and grow. And it's really important that those new sectors are highly productive sectors, of which renewable energy is an example, because that's where we got productivity growth from, and that's where economic growth comes from. So, taking that specifically to the Skye economy, so the labour market's not uniform. I think we're all agreed that tourism accounts for a large proportion of jobs in Skye, but not everyone will want to work in the tourism sector. Others will have different skills and different ambitions, so it's important that the opportunity is there for people to work in highly productive sectors. And it's also crucially important that Skye is not over-reliant on one sector of the economy. I guess we discovered the consequences of that during COVID. The next and related one I think is probably around housing, and I guess it's the same general point about things adapting, but I think more particularly here it's just the sort of scale of the employment here is not such that it's going to impact significantly on the housing market. And the final point, if we move on to that, about whether it's already taken account of. Yeah. So the socio-economic assessment in the EIA does take account of these structural limits, although actually I'm afraid economist terminology means it's perhaps not obvious, but at paragraphs 13.614 to 13.616, sorry, that's the CD 1.2, the EIA chapter. That shows the adjustments being made for what economists call leakage, which is about basically impacts benefiting those from outside the study area, so taking account of what happens in Skye or out with Skye. And displacement is an adjustment for this impacts that would have occurred anyway.
So just in as a specific example of a leakage, what would that be? Workers being brought in?
Yeah, that would be an example of that. So the opportunity would be available for people in Skye, but if there's not the labour supply, then people would come in. So that would be an example of leakage. So the figures that are quoted as the headline impact are net of these effects. So there's already been an adjustment for that. A displacement would be where, if you like, say somebody moved jobs from what they were currently doing to work on the wind farm, and it wasn't possible to replace that person in their previous employment. That would be an example of displacement.
Ms. McLeod, do you want to respond to that?
Yeah, there are huge structural limits in Skye's economy at the moment. As Mr. Blackett's mentioned, I think most people here who have had to come into Skye have struggled to get accommodation, and whilst there might be available bed nights, that doesn't necessarily mean that the demand at that particular time is met, and I can't imagine that construction projects are going to work on the basis of there's 2 nights available this week and 5 nights next week and 3 nights the week after. There's going to need to be a construction project that is continuous and will have a continuous demand and isn't necessarily going to stop because the Tongadale Hotel has 5 rooms available this week that we're going to have to, but none next week. We've had a huge increase in day tourists to Skye, and that is due to the pressure on accommodation. We've got a number of tour companies that are actually based in the Cairngorms and coming to Skye for the day. Huge amounts of travel, and that is down to the availability of accommodation and also the cost of accommodation. The cost of accommodation is becoming quite prohibitive at the moment, particularly for businesses who are often working on budgets and trying to keep to reasonable costs. So to pay 250, 350 pounds a night for a room for most businesses is unachievable or certainly very challenging. I know personally myself, we're fortunate enough to have a spare room, and on a number of occasions we've had people travelling to the outer isles who, for one reason or another, have been caught up in traffic disruption, accidents on the road, unable to meet their ferry, and have phoned up saying, help, can't find a room in Skye. And on a number of occasions, people like myself and others in Skye have had to just open up their houses and make space for people to come. And that's quite a regular occurrence here on the island. In terms of jobs, I mean, the reality is that since Brexit, we have a huge shortage here. An awful lot of the tourism businesses are actually operating on 2/3 of the staffing levels that they had pre-Brexit. Huge pressure on the staff that are working because they're expected to do much more because there are less people in order to deliver that work. In the last 20 years since I came to Skye, the high school population has dropped from 800 to it's dropped from 800 to just under 500, which is almost a 40% drop. So as the headline numbers of population on Skye has actually increased, the structure of the population is extremely worrying, and we don't have the young people coming through in the volume that we used to, who have accommodation because they still live at home, and therefore would provide a ready workforce. In the coaching,
Just let me check.
Yeah.
Can you hear all that?
Yeah. In the Skye and Rassay futures plan, I think it's document reference CD 9.2, there are a number of challenges stated there, including for Skye, climate change, transport challenges, declining working age population, destination of pupils, deprivation, fuel poverty, difficulties accessing housing, employment exposure, town centres and village centres. And it goes on to say large areas of North and West Skye and the Isle of Rassay are identified as fragile areas. These are areas characterised by declining population, underrepresentation of young people within the population, lack of economic opportunities, below average income levels, problems with transport and other issues reflecting their geographic location. In the EIA study at section 13.4.18, it states that the effects on community services have actually been scoped out of the study. And the table at 13.5, the economic data is based on Lochaber, Skye and Wester Ross, which is quite a sizable area. And
just slow down so that let me catch up with that. Can you give me the reference again to the 13.4 I got? But
yeah, 13.4.18. So that's the effect on the community services. It states there that that's been scoped out of the EIA. And the subsequent reference was 13.5. The economic data is based on Lochaber, Skye and Wester Ross, the employment data. Now, Lochaber, Skye and Wester Ross is a sizable area, much larger population. I believe it's in the region of about, that whole region's 3 times the size of Skye. So, therefore, the economic data will be quite different for Skye when taken in isolation to that area that covers quite a sizable part of mainland Scotland as well. The other point I would make is that the economic effects are only looking at this one project and not the cumulative effects of the overhead line, all the other developments, all the other 7 or 8 wind farms, the workers' camps, the power stations as well, so the substations. So I feel that the economic data has been diluted down to quite a very small effect when actually we're in quite a precarious position here on Skye economically.
okay, can we just pause and put some of those points to Mr. Blackett? So
could I, by way of a preliminary point, could I ask you, or ask Mr. Blackett to explain his role in relation to the chapter within the EIA report, because he's not the author of it as such, but he has checked it. I think, to be fair to everybody, they understand his role in relation to the chapter.
yes, of course.
So I think probably best unless I wasn't the author of the chapter, but when appointed to assist with inquiry, I did of course review the chapter before I agreed to do that, and I was broadly happy with the findings of the chapter. I think actually in terms of one of the specific points it was made there, I think had I been the author of the chapter I might have used a different definition of the economy. However, I don't think there's any disagreement about these challenges. I agree with everything that was outlined there, that these are all challenges for the Skye economy. I think where we differ is what to do about it. So I I guess if you see the economy as a sort of fixed thing, then you think, well, there's no more room for anything else. But that's not how economies work. They're dynamic systems. So it's like, I guess, as I was mentioning before, so it's not a good economic strategy to say, well, we can't do any more, let's pass up opportunities. That's not a good recipe for economic success.
I think, to be fair, sorry to interrupt, but you didn't hear Ms McLeod say that.
Well,
She's not to be taking as saying you can't do any more, because that wasn't in her evidence.
so I didn't intend to suggest that had been said. The key point is what an economic strategy should be in such circumstances. And my evidence is that what you require to deal with such challenges is you need good quality jobs in highly productive sectors, and that's what this project contributes to. You need good high quality jobs in productive sectors.
So in terms of the particular points that Mr. McLeod raised, there is the question of the economic data, the data being for a wider area, for Wester Ross and Skye, and Kyle as well. Yeah.
Lochaber, Skye and Wester Ross.
Yes, so it might have been better had a smaller area been used, but I don't think it gives a rise to any concerns, because we're agreed that the economy has these challenges.
And there was the scoping out of community services, so it's not expected that construction workers from outside Skye would have a significant effect on the demand for housing, health or education services. I suppose that links in with the point that Mr. McLeod made about cumulative impact. It may be fair to scope out the individual impacts of the proposed development, but cumulatively with other projects that Mr. McLeod listed, and I think actually it might be useful. There's a document listing a number of different projects, listing projects that are in the pipeline. Just let me check what document that is. I think it's called, is it Fact Sheet or something like that? It's called, it's CD 15.13. So have you got that? I'll just open it from... So there you see the, it lists existing generation, and then it lists a number of proposals, and then it lists decisions pending. So there's obviously, it lists a number of projects there that are that potentially might have cumulative effects in terms of the economy of Skye. So is there not a significant effect that arises in respect of community services with all those projects taken together cumulatively?
I think in terms of setting even the cumulative impacts in context, so we have the population approximately 11,000 at the last count, and the last statistics we have were 650,000 tourists spending 2 million nights a year. I think probably everyone agrees that's probably increased since then. So the context here, so in this particular project, we were talking about sort of 20 job years in Skye during the construction period and 1.4 jobs ongoing. Now, obviously we don't have the equivalent figures for all of those cumulative projects, but that's going to be the sort of order of magnitude. So even if you add all of those up, in the context of the existing residential population and the number of visitors, it's a pretty marginal effect.
Does that answer the points you raised, or is there further comment to make on that?
Just the point on good quality jobs. Absolutely, we're always looking for good quality jobs, and I personally employ 20 people in Skye year round, and I hope they consider them to be reasonably well paid. But we still have an awful lot of vacancies and difficulties filling jobs for the hospitals and at the schools here as well. Real challenges filling vacancies, and sometimes you can fill vacancies, people come and they might get temporary accommodation and then just can't get the permanent accommodation, and there have been situations where people have gone because of the inability to get housing. It really is a huge challenge. A lot of the tourism businesses I've mentioned are operating on about a third less staff than they had prior to Brexit, and it really is. I live in Skye, so and I know the situation here. Don't necessarily live in the cities, but anecdotally I understand that there isn't quite the same challenges in terms of filling posts that we have here. And there's vacancies that anecdotally, again, about 1,700 2 years ago, I think there was a study, had said of job vacancies on Skye that cannot be filled. So there's a real problem with housing, whether that be temporary for tourism or on a permanent basis. And it's a real structural problem that we're not going to fix overnight, and does need public sector help on quite a considerable scale in order to address the shortfall that's required.
Just to follow up on that, Mr. Brackett mentioned in his first answer the point about leakages, that he gave the view that the study had taken the structural economic issues in Skye into account in working out the benefits. What's your position on that? Are you do you think that what's in the assessment is simply wrong? Or?
I'd kind of question what it's based on, if it's been based on a much wider population basis across Lochaber, Skye and Wester Ross, and also I'd be kind of concerned about the aspects that have been scoped out. So again, I can't really comment on what the base data is, given that it doesn't necessarily look like it's just purely looked at Skye.
Yeah, I mean, I think the EIA chapter is clear that it looks at jobs at the level of the Skye economy and the Highland economy. And, for example, in the construction period, we've got 20 job years in Skye and 80 job years in Highland as a whole. Now, had Skye not had some of the challenges that have been highlighted, it's possible that many of those 80 jobs could be taken by people living in Skye. So that's the way that effect has been taken into account. In terms of
Sorry, just to follow up on that, the jobs generated are specific to Skye. The economic data is from the wider area of Lochaber, Wester Ross and Skye.
Yes, but that's really just to set the economic context. The calculation of the benefits is only for Skye, or actually probably technically it's Skye and Rassay, because that's usually the area that's looked at.
Sorry, I interrupted you.
Sorry, there was one further point about the vacancies and unfilled vacancies. I would just make the point that the examples raised, this project's not going to be competing for the same skills. And I guess in terms of the broader point, again, I would agree that some of these challenges require public sector assistance. They also require private sector growth sitting alongside that. It's very difficult to do one without the other. And renewable energy is clearly one of Scotland's biggest opportunities to achieve that. Well, the biggest opportunity, actually.
By the challenges, you mean that the structural limits on Sky's economy, that those would change with growth arising from development. Is that what you're saying?
Yes. So if it was only a public sector intervention, it might deal with short-term issues, but it wouldn't address the underlying fundamental issues. They can only happen with productivity growth, which the public sector intervention can contribute to, but it also needs private sector growth.
Okay, I think I've got most of what I want in this area. I'll give both of you one more opportunity to comment.
It's interesting because I think there's been a lack of joined-up thinking, and there's public sector intervention required here, but also opportunities to be more creative in terms of the solutions. And for example, with the workers' camps, I've written to a number of different agencies around, rather than bringing in temporary porta cabins and piling them up in fields around Broadford, whether that money, because that will cost money, can be better spent in terms of thinking more strategically about housing projects and delivering more permanent housing that could house the temporary workers and then be handed over, for example, to the housing association at the end of the project. And rather than spending money on providing temporary accommodation, that it's actually used much more effectively to try to add to the structure of what's here and the infrastructure that's here to deliver better solutions. We can only do that by looking at the projects cumulatively and the impact on Skye as a whole, and not just salami slicing down to one project and only considering that one project.
Actually, I totally agree with that point. And that there's ongoing work, certainly across the renewable energy sector, to do things like that. And we don't know for sure, because it's too early, who the lead contractors would be for this project. But there are only so many out there who do this sort of work, and most of them are involved in these industry-wide initiatives to address basically solutions like the ones outlined. It's just an issue. It's getting into the practicalities of the delivery rather than the consenting process.
So just to be specific, in terms of the projects listed in the SWIG mode, the info, I forgot what it's called, fact sheet, in the SWIG fact sheet, there aren't specific discussions going on between the applicants for those proposals, but in your view, it's an approach of the industry overall. Is that how I should understand it?
Yes, I'm not aware of anything specific, although SSEN have been heavily involved in some of these industry-wide initiatives. So I would expect, therefore, that Skye would be part of their thinking. And I guess, given the scale of that project, others working on the back of what they do would make sense.
So we move on to the impact. Is that, yeah, it was just coming, right. I think the first three questions there can be taken together. They're all about the landscape and visual effects of the proposed development, or the cumulative landscape and visual effects, and the evidence about it seems to start. Is it cutting off? Okay, yeah, well, it's working for the moment anyway, yeah, good. Right, and the evidence for whether there are landscape and visual effects David's got another one there. We'll carry on for the moment. So if you want to address those three questions first, Mr. Brackett.
Okay, I guess the short answer to the questions is there is no evidence to suggest that landscape and visual effects have an impact on tourist behaviour. This is something that I've done lots of research on over the years, not least of which because my business works in both the energy sector and the tourism sector. So we're particularly interested in whether there's potential for conflict there. And the first wind farms were constructed in Scotland 30 years ago now. People have become used to them and expect to see them in the landscape, which I think probably explains why the fears that are sometimes raised haven't been seen once the actual wind farms have been developed. I have dealt with this topic a number of times at inquiries now. I think Clyde Wind Farm was the first one, which would be certainly more than 20 years ago now. Clyde. Yeah. But there have been a number of inquiries where this issue has been raised, and the answers are the same, but we're getting more evidence every time a wind farm is developed that these relationships are not seen in reality. It's other things that influence tourism behaviour.
Just in terms of before I go to Mr. McLeod, in terms of the bigger economic study, which is your study, isn't it? Yeah. Is it fair to say that while it doesn't find evidence of an effect of wind farms on tourism, it also doesn't disprove an effect?
Well, it's never possible to disprove a negative like that. But what it does do, it looks for all of the wind farms developed in a period of time and asks the question, so what did happen to tourism in the vicinity? And there's no correlation between the trends. We didn't particularly look at an island economy, but most of these projects are based, I guess, because of where wind farms tend to be developed, they tend to be in rural areas where landscape issues will be a driver of tourism. So to that extent, it seems that it's relevant evidence for this project.
I'll ask you to comment on that, but also I do have a question. If wind farms do have an effect on, or the landscape and visual effects of a wind farm have an adverse impact on tourism, is that correlated to the degree of those landscape and visual effects? But I'll invite you to comment on what Mr. Brackett said at the same time.
Okay, so I think there's sort of a number of points to make, but one point would be that the impact on tourism always seems to be focusing on once the wind farm is operational. And I think there's two aspects to consider. There is the operational aspect, but there's also the construction aspect, which if we were talking about one project putting up 9 wind turbines, that construction impact would be far less significant than if we're talking about the cumulative impact of all of these projects happening either consecutively or cumulatively, but certainly from talking to developers, we're talking about a period of at least 5 years, is what I've been told. So I think there's two things we need to consider here, and generally when looking at studies that are done, it focuses on the operational side of things. So I'll talk first of all about the operational side. Operationally, yes, there will be a significant visual impact from doubling the size of the existing wind turbines that sit relatively low in the landscape in comparison to when we double those up. So that absolutely will have an impact. I'm going to make a really obvious statement here, but Skye is an island, and that is not the same as the mainland, and particularly where wind farms are located. Skye is anecdotally the second most visited place after Edinburgh. However, Portuguese population means the Scottish Government's classification classifies it as being remote rural. So we find ourselves in quite a unique position where I don't think we can take a study that's looked at primarily mainland projects. I think there's one project that's Orkney based, which is quite a small project of 5 turbines. There's maybe some more in there, but from my reading of it, that's what I picked up. So I don't think that studies based on the mainland are comparable at all to what happens somewhere in Skye. We have some of the most stunning scenery. We have, I think it's 12 Munros alone. People come here for the hill climbing. And when you stand on top of the Coolins and look across the landscape, you see it all. You see everything. You see the turbines. You see the relatively small turbines that we have here at the moment at 100 metres. They really do stand out when you stand on the top of Scuth na Banachgy. And I don't suppose you've got time to do that tomorrow, but certainly it's recommend coming back if you haven't done it before. And tourists come for the scenery. There isn't an awful lot of activities here. There's not a lot of visitor centres. They really do come for the scenery, and it will have an impact. How significant that is, I don't know. But my concern is the 5 years, or 6 or 7 or 8, however many it takes to get all of these projects up and running, and the impact that has on tourism. We heard yesterday, a bit optimistic, I think, getting from Broadford to the north of Skye in the times that were mentioned, even during the summer at the moment here. Never mind when we've got AILs on the road. But that gives me grave concerns in terms of the logistics and the infrastructure, the fragile infrastructure that we have here in the islands. I also have an office in Benbecula, and we have a lot of clients in the Western Isles, and this is a lifeline route as well to the Western Isles for those living in Harris, Uist, Barra, Benbecula, all the way down, and it's vital for them. The road is part of that ferry timetable. The buses run to the ferry timetable, and any delays that we have on all of that will have a huge impact. A lot of our supply chain routes that come into all the restaurants and shops here generally come from Inverness, but certainly mainland-based in a lot of cases, and that will have a huge impact on tourism.
And you're here for the transport session yesterday.
Yeah.
Are you more or less concerned after that, and why?
I'm more concerned about how optimistic a transport expert was about the time it takes. As most people who live in the islands will have been stuck behind AILs before, and the journey time, and actually another point to make would be how badly AILs are communicated to people who live here. I've often got caught up in AILs where I didn't have a clue until I got to the tail of traffic that's going back about a mile, and you're crawling along the road at somewhere between 15 and 20 miles an hour, and you're then scrambling about hoping that you can get a mobile signal in order to phone ahead to delay appointments if they can be moved on a fairly regular basis. So I'm actually more concerned than I was prior to yesterday, just because I feel that the numbers that we heard are extremely optimistic.
And so I think we've moved on. Mr. McGuire has responded to the points about landscape and visual effect, and raised the point that's further down about the impact of tourism on from delays to traffic. You were here for the Highways and Transport session yesterday too. How has your view been changed in any way by that session?
Well, I mean, I think what was clear from that session was that these things are planned in great detail, and the construction traffic management plan that was discussed, I guess, a great length yesterday, is the place to deal with these issues. I did also have a couple of factual things.
Can I ask you about, before you go there, your view wasn't changed by the evidence on cumulative effects yesterday in terms of transport?
No, it sounded to me like the situation could be managed. I mean, I'm not a transport expert, but the impression I was left with was that these are common issues that are dealt with by experts, such as the transport witness, and that's how that expertise would be used to plan this one.
I'm sorry I interrupted you before, so go ahead with what you were going to say.
I said a couple maybe of factual things, or at least one factual thing on the research evidence on wind farms and tourism. So certainly the bigger economics report, the 44 case studies included in it, they look at what happened before the wind farm was developed and compare it with the period during construction and once operational. So, if there was anything happen in the construction period, that would be picked up in the study as well. But there wasn't. There's neither a temporary nor permanent effect.
Is there any of those examples that are analogous to Skye in particular?
No, but we do have an obvious one, which is the existing wind farm, and I don't think there's any evidence being presented that it has had a harmful impact on tourism.
If I might, can I ask, have you carried out any studies anywhere on turbines 200 metres high in a tourist area?
It's a relatively new thing, so we don't have evidence to be sure. I guess I would suggest that the change from no turbines to 100-metre turbines is more of a change than from 100-metre turbines to 200-metre turbines. So,
and so what are the highest turbines that you've studied in the tourist area?
I don't recall. I would have to look at how high the turbines are in each of the case studies.
I can't recall if it's shown in your document. Well, I don't know if we can take that any further, but yeah.
May I just have a moment?
Sorry, do you want to respond, Mrs. Gray? I think we could have a response from you and then a response from Mr. Black, and then we can move on from this section.
Yeah.
Although I think that there's one further question I had about the white-tailed eagles, which I think was Scabost Community Council's question, which you could... No? Okay.
No, as regards Scabost, I was actually directed only to work on the views of the actual Scabost area. But one of the points that, some of the points that Ms. McLeod was presenting, it it relates to a lot of concerns in the Scabost area about the island's reputation as a tourist area. One of the key attractants to the island, certainly over the last 5 or 6 years, is in relation to the kind of filmmaking that was made on the island. And I think asking any of the foreign tourists that come to visit the island, they often refer to those films that were made that present the island in its natural, beautiful form. One of the concerns that a lot of the people certainly that brought up issues in the Scabost area was that if those kind of views get lost, then that kind of the film industry would not use Skye as a backdrop in the future, and that as a key attractant to a lot of visitors to the island in the future would be lost.
So, I think that was right. Okay. Well, I'll get Mr. MacLeod to respond to Mr. Blackett as well. I don't know. What's the convenient thing to do? I think, if Mr. MacLeod responds and then Mr. Blackett responds to both Mr. Salt and Mr. MacLeod, is that okay? Right.
I'm going to go back just one step, because there's one further point just from transportation that I think is really important and quite important, very important to the tourism side as well, is that the study that's been done so far looks at the existing situation with the ferries, but actually there are 2 ferries being built in Turkey at the moment, so they're more likely to actually be delivered, which will change the situation with the ferries on Skye, so that rather than having one ferry that serves 2 islands, we will have 2 ferries serving those 2 islands, and therefore there'll be less gaps between those ferry sailings, which will create its own challenges from a transportation perspective. And none of those planned changes have been taken into account from what I can see so far, but that will add another level of complexity to the timing of AILs, for example, and some challenges as well to bus timetables and things like that, I'm sure, as well. But I'll just kind of...
Just to be specific, that's for Rasi and...
So that's for the Ook to the Western Isles perspective. But just to kind of confirm what David was saying, Skye is unique, not just Skye, but also the islands off islands. Isle of Rassay, for example, I couldn't find any mention of Rassay at all when it came to the EIA and transportation. So there are disadvantages to being on an island, but being an island off an island has much greater disadvantages, and that must be considered. We have the Islands Act now. The Islands Act was created in order to create some protections for islands and islanders, the unique situations and circumstances that we have here, and that really can't be forgotten, and it's why tourists come, particularly to places like Rassay. It's a step away, it's different, it's got a sense of being in a place that is like no other. And when we start creating an industrial landscape around what's a beautiful natural landscape, it will have a significant impact on everyone who lives here, but in particular, it will have some impact on tourism.
In terms of Rasi, you were thinking in terms of transport in particular?
Yes, transport in particular, and again, they're quite dependent on the bus timetable linking with the ferry timetable. The kids can hostel here, but quite a lot of them actually travel backwards and forwards. So just their daily lives will be significantly impacted by any disruption on the A87.
Mr. Blackett.
I don't think I can really deal with the transport issues. That was probably for yesterday.
Well, I wasn't suggesting you should. No, I was hoping you'd be able to respond to the points about that were raised by Mr. Salt about filming and the further points raised by Mr. MacLeod, but not specifically about giving any expertise on transport.
I mean, I understand where these fears come from about the potential impact on tourism, and I've heard them on many projects. I guess all I can say is my experience is that once projects are delivered, these fears have not been realised elsewhere. I think in terms of specifically about the film locations, whilst I've done some work in the creative industries, I can't claim to be an expert on how those decisions are made, but I would certainly observe that locations, Outland is a good example. They've used many locations in Scotland where there are wind farms in the vicinity, but the technology in the film industry these days means that that doesn't necessarily cause a problem.
Okay, well, I'm going to move on from this section unless anyone has anything else to raise. The fourth point is community benefit payments. I wonder if we can deal with these points together. Essentially, the first question is whether community benefit payments are a material consideration at all. That's what Scottish Government Good Practice principles say, that they're not a material consideration in a planning application. So two questions follow from that. One is whether the socioeconomic benefits that might arise from community benefit payments are something that can be taken into account in decisions at all. And the second is there any locus for ministers to consider whether community benefits payments are less than they might be elsewhere?
I guess the first part of the question is maybe primarily a legal question, but I can certainly give a perspective on the benefits from community benefit, the socio-economic benefits, and also a perspective on what's offered and what the existing wind farm has offered, how that compares with standard practice. In terms of the benefits, so what we're looking at here on £5,000 per megawatt index linked is the commitment. So based on 59.4 megawatts, that would be 297,000 per year. And as a rule of thumb, obviously the benefits that arise depend to a large extent on what the community decides to do with that funding. But as a rule of thumb, we would expect spending of 50 to 60,000 to support a job, whether that job is in the social economy or whether it's in construction, so it depends what the money is used for. So that level of community benefit might support 5 or 6 jobs in the locality each year, as it were, during the operational period. As far as the scale of benefits that have been offered, £5,000 per megawatt index linked is very clearly the guidance. The applicant has been very much pioneering in the community benefit they've offered in the past. The existing wind farm, the initial turbines are based on 1,400 per megawatt, and the 2 extended ones were based on 2,000 per megawatt. Now, at the time that wind farm was developed, and therefore the time that all the financial decisions were made, that represented in advance of good practice. So they were very much offering a level of community benefit and indeed offering community benefit that others weren't offering. And in fact, one of the documents submitted by Ms MacLeod provides some evidence of that. In the south of Scotland, around that time, it shows that 1 to 2,000 per megawatt was what was typical there, and that would have been the same elsewhere in Scotland. So I should give the reference to that. Just give me a moment. So CD 15.17, and specifically pages 22 and 23 of that document, they show in the south of Scotland the sort of evolution of community benefit payments. There's a graph there on page 23. So that's probably electronic, page 22, 23.
Is that the graph from figure 5.2?
Yes. So as we can see from that, what's happened, if you look at sort of 2007-8, the average there well below the 2,000 mark. In fact, it's below the 1,400 mark that the existing wind farm offered. And it can also be seen in that graph that even by 2021-22, the 5,000 hadn't been reached yet as an average. And the reason for that is simply the timescales involved in developing a project. So many of the projects come in on stream, and those at that time will have been ones that went through the planning process and the development process several years in advance of that, when either the guidance was new or it hadn't yet become standard practice. So there is a bit of a delay from the recommendation being made and, if you like, money eventually being paid from operational wind farms. So that sort of explains the time frames involved.
And would this be an opportunity to bring in the new document that you provided, 911, CD 911?
Yes, I guess what that does, it covers two things, or 2 points. One is that it sets the implications of a community benefit above that level in some context. So I'll deal with that first. So the background to that document was Highland Council's policies seeking to increase community benefit payments. And we undertook analysis of the detailed financial analysis of a range of proposed projects in the Highlands to understand where they were at in terms of the financial decision-making process. So what was a likely rate of return, and basically would the project make it through a financial decision? Would it meet what they call the hurdle rates, which tend to be around about 7 or 8%. So the investors will be looking for a 7 or 8% return on their investment. And what that showed was an increase in community benefit of the level that Highland Council had been proposing at that time would tip projects from being feasible to not feasible. And so the consequences of that, although it sounded like the policy would generate more community benefit, there'd be many, many fewer projects going forward, so the actual cash available in community benefit would decline substantially. And actually, then what would also be lost would be all the socio-economic benefits from these projects. That would not be realised, and that would have a significant effect. So I guess what that document shows that, and I guess it also provides a wider context in terms of financially how does this sector work. It's profitable, but it's not hugely profitable. It's an acceptable rate of return, and that's required to secure investment. But it's also it's also just at that point where the investment decisions are being made.
Ms. McGrath, you've produced some evidence on this.
Yes, I have. First of all, say that the track record of making community benefit payments has been poor to date across the industry. And just going back to the baseline report that Mr. Blackett referred to there, that's been prepared on the south of Scotland, on page 1 there, it outlines so in 2022, the average value of community benefit funds associated with operational wind farms was £2,537, whilst the equivalent figure for planned wind farms was £3,986. So falling well short of the 5,000, but certainly taking into account the fact that perhaps earlier projects were not quite promising that level, the amount that's actually being paid falls short and well short of what's been promised, and that's very much in line with what we see for Aketil wind farm, where the payments to date, and I've gone back and had a look at the 16 years of accounts of Aketil wind farm, and the amount paid has not met £2,000 per megawatt of installed output, which is disappointing that it didn't actually meet what was promised. In fact, in the year ending December 2020, 31st of December 2020, £1,000 was paid, whilst £2.5 million of profit was made. So that year is particularly disappointing. So, I would kind of say that it's all very well to have guidance where amounts are promised. These are not legally binding documents, they're not legally binding agreements, and therefore communities are being handed whatever it is that the developer decides to hand them, rather than anything that has any grounds in a legal agreement that they can go back and ask for. So I've also kind of looked at the analysis, so for this, in the 16 years in Aketil up to 31st of December 2023, and that's all just from the published accounts, so I can't go beyond that at this stage because the accounts for December 24 have not been filed. The profit in those 16 years amounts to 60 million from a turnover of 139.5 million. That's significantly more than the 6% that Mr. Blackett has talked about. And I also note in Mr. Blackett's response to my hearing statement that he's questioned these numbers. These numbers have come from the statutory accounts of Aketil wind farm and have been audited. They're not my figures, they're the developer's own figures. They also include depreciation. I note that Mr. Blackett had questioned the capital costs of this project were excluded from this. They're not, they are included. That 60 million of profit already takes account of 22 million of capital costs, because the depreciation, the capital cost of the project is spread, in this instance, they're spreading it over 23 years. So the total capital costs for the Aketil project are 34 million, and in those 16 years, 22 million of those have been accounted for. Therefore, and this isn't just for the Aketil wind farm. I've had involvement with a number of wind farms in the Western Isles, and they're significantly more profitable than 6%, or perhaps these communities are just particularly good at running their wind farms, and they're returning 34 times from a study done on the Point and Sandwick Trust, 34 times back to their communities than the communities would receive, even if they were getting £5,000 per megawatt of output. So there are different ways of doing things. Mr. Blackett talked earlier about opportunities, and there are many opportunities for communities to own or participate in wind farms. But certainly community benefit at the moment doesn't even reach the levels of the £5,000 per megawatt. The other point to make is that at any time the developer could have chose to have increased their community benefit levels. It isn't a legally binding agreement, it's guidance, and I'm sure the Scottish Government would have welcomed a developer going above and beyond what they had initially agreed back in 2008.
I'll give Mr. Smith an opportunity to respond to this, but just for the record, I guess the answer to the questions I was asking about the relevance of community benefit, that's going to be a matter for submissions, is it? Ms. Campbell?
Yeah.
And, yeah, Mr. Wilson. I think I'll give Mr. Black an opportunity to respond.
Okay, I think there's probably quite a few points there. The first, I guess, is on the community benefit paid by the existing wind farm. So that has paid in community benefits so far £900,000. That's to January of this year. I guess on the point on that I think probably connects to the last point about a decision could have been made to increase the payments. I'm not aware of examples of that happening, and the reason that's unlikely to happen is because clearly that's a big part of the cost base for a developer, and the financial decision will have been made at the time the project was given the go-ahead based on a stream of commitments that were being made going forward. And so if you change that, it's likely to have quite an impact. And I'll come back to that point in a moment because it's related to something else. The South of Scotland Enterprise report, actually, if I didn't make it clear already, I know that report because that was also one of Big Economics reports. That didn't show that community benefit paid was less than promised. What's going on there is the effect I mentioned earlier, that there's a time delay between, in terms of a decision, an offer being made and a wind farm becoming operational. So there's been an upward trend in community benefits, and the average will be 5,000 in another year or two, and that simply reflects the time frames for decisions. I think looking at the profitability of wind farms is interesting. I was quite surprised to see the calculation of suggesting more than 3,000% return. I mean, I'm not aware of any business who makes it. I'm sure McLeod doesn't have any clients who are making profits at that level. I think maybe the issue here is what's the right measure to use, and it may be the return on share may be a valid measure to use in many businesses. It doesn't really work for a wind farm, or indeed for any sort of capital-intensive project, because what needs to happen is most of the costs are capital costs, or at least half anyway of the lifetime costs, and that they need to be paid up front before there's any income. So the measure that's usually used is looking at the capital costs plus a stream of operational costs compared with the income over time. And what you calculate then is a return on that initial investment. And the sort of 6 to 8% that I mentioned earlier, that's what that measure is. So it's not a return on share, it's a return on capital, if you like. And it needs to be, well, if it was much higher than that level, then there would be a much greater flood of capital investment into the sector in Scotland than we see. The projects that are sitting there consented but not yet developed, they would all be developed by now. If certainly if it was 3,000%, but even if it was just a little bit more than 6 to 8%, they would be. So yeah, that's how these decisions are made. So I think we're probably not comparing like with like there. So you're looking at depreciation because they're not upfront costs. It's a slightly different thing, but a significantly different thing.
I'd like to move on from this section, but unless you have something specific to raise.
Yeah, I asked Ms. McClyde, but I think she does actually.
Yeah, well, I do probably got a lot to say, but anyway, the sort of two things I think here that are kind of being mixed up. Even if we took into account the total capital cost of that entire project in those first 16 years, we would have 49 million versus a turnover of 139, which is still a very, very significantly profitable project. I do understand how wind farms are financed, and they are financed significantly with debt. So that the capital is purchased at the beginning and the debt is repaid. The debt is repaid through the profits of that's generated over the lifetime. So the percentage return on what was £100,000 worth of capital put into Aketil Wind Energy Limited at the beginning is valid. So it is 3,181% return, because the ordinary shareholder who put £1 in at the very beginning is getting a return in those 16 years of £509. And the reason I did that calculation was actually, and I don't know, is this coming up next, but as well as community benefit, there's also share ownership. And the Scottish Government encourages shared ownership. There is a mechanism whereby the Isle of Skye Renewables Cooperative participates in the Aketil wind farm. It is not shared ownership, however, because the Isle of Skye Renewables Cooperative has actually put £1.5 million into this project. But the total return on its shares in those 16 years has been £1.75, contrasted against the ordinary shareholders of Aketil Wind Energy, who are getting a return of £509 per £1 of ordinary share capital. So the point there was actually to highlight the difference between the members of the Isle of Skye Renewables Cooperative on the Isle of Skye and the return that they get versus the return to the ordinary shareholders of Aketil Wind Energy, and to highlight how different the treatment is of those local shareholders of the cooperative that participates in Aketil Wind Energy, and the fact that that's not seen to be in the document that I provided from Community Energy Scotland, where they talk about credible share ownership, which is what they're encouraging developers to look at, where communities are given an equitable share and not just a mechanism that allows them to participate, but not necessarily given the same returns as those participating in the developer.
I think that does move us on to the next section. So I think the number of points raised about ownership and profits there. I think obviously Ms. McLeod has suggested an alternative way in which it can be developed as well, or in which a wind farm could be developed as well. Before I go to Mr. Black, I take it that, again, these are matters for submissions as to whether ownership and profits and alternative development can be can be a relevant consideration for ministers. Is that right?
I think it'll have to be, unless you want to listen to me for about 25 minutes.
Right.
We don't want to do that. So, yes, it's much tidier to put it into a closed submission.
Right.
So yes, it would be covered in legal submission.
So I'll give Mr. Blackett an opportunity to respond. And I think we'll have a couple of responses on this. I do have evidence on this, and I've heard, which I've read. So if we can, Mr. Blackett, if you want to respond to Mr. MacLeod.
Can I just check before that? I understand there's two kind of main issues to respond to. One is about the current shared ownership model, and one about the potential alternative community wind farm.
Let's take the alternative community wind farm second, but just deal with the first point.
Well, I guess in terms of the shared ownership model, I mean, I don't think it's reasonable to say that it's not shared ownership. It's the advantages of the co-op model that have been implemented here are that it's a model that works. So there have been incidents where developers have said, yes, we're open to shared ownership, but if there's not a workable model, it's not going to happen. What we have here is evidence of a working model that has been implemented here and subsequently in many other projects. And the applicant here really is again a pioneer in these matters, and is very much in the lead in the industry in this. In terms of how it's worked, the co-op model's been put together by an organisation called Energy for All, who I've had the benefit of speaking to understand in a bit more detail how it works. And what that does is designed to reduce the risk to investors, and it compared with a straight, if you like, equity investment in the project. And it does this in a number of ways. One is that the buy-in of shares doesn't happen until the wind farm is commissioned. So at the point where it's gone ahead, so that risk is taken out. There's also an element where part of the investment is in the form of a loan rather than equity, and that gives a sort of fixed rate of return, or if you like, almost like a guaranteed element, and then an element which is more equity related, so that allows for, if you like, if it's more profitable than anticipated, then the shared owners get a share of that. The individuals invest in the co-op, and the co-op invests in the wind farm, is how it works. And so if you like, the level of investment in the local community depends on the level of local interest. So the local community gets first opportunity, and how much investment depends on how much appetite there is in the community. What Energy for All do is they help set everything up. And actually in the case of the existing project, so the co-op itself was established in 2007, but the work started in about 2003 was when Energy for All started working on it, and it would be the same for this model as well. Although the co-op itself won't begin to market the opportunity until the wind farm is being constructed, the work has already started in terms of figuring out how it will all be structured. And so what they'll do is they'll help recruit some board members, and usually what they do is they look for well-respected members of the community who are also interested in investing themselves, and they will prepare a share offer, they will market the opportunity, they'll do all the legal work required, and they'll purchase the shares. Now what's happened in terms of the existing co-op, there were investments, the total investment was 1.5 million, and so far the interest payments received have been 1.9 million, and that works out as an average of just over 8%. So it's a reasonable investment, and particularly in the context of pretty low interest rates that we've had over the last couple of decades, that benchmarks fairly well. And I think because of this successful model, I would expect there'll be quite a lot of interest in the new model. You know, people can speak to members of the community who invested previously and find out how it works, and that's probably a more advantageous position than a completely new scheme where there might be no knowledge of anyone. You know, people will tend to be a bit suspicious of financial models they're not familiar with. So the fact it doesn't exist in one, I think, gives a chance of the new one being successful.
And I suppose Ms. Mackay's point that's unique is that the community investors are not on the same basis as the shareholders, as the ordinary shareholders.
That I think is purely down to the way it is structured, and I don't think that's the right measure to use. The return per share it doesn't really tell the story of how it works, because the co-op gets a return that's not, if the shares of the co-op has, they're not comparable, with the shares that the company has. So it's not the same class of share. So it's not comparing like with like to compare the return on share. There's that kind of broader return on capital investment as a better measure.
Well, I should probably declare that I am a member of the Isle of Skye Renewables Cooperative, and I certainly took the decision of originally investing on the basis of it was going to be a reasonable return. However, it's certainly absolutely not comparable at all to being an ordinary shareholder of the Aketil wind farm, and it doesn't meet the requirements or in terms of what's being looked at now in terms of community share ownership. And at the recent AGM of the Isle of Skye Renewables Cooperative, we were told that in terms of the new project, quote, what we don't have any real insight into at the moment is what the redevelopment or the effective redevelopment will have on the Isle of Skye Renewables Cooperative. We were told it was at very early stages, and also there's a couple of key people that were working on it, but they have now left Nadara. And the chair then also went on to say it isn't legally possible with the new project to do just exactly what we've done again. There's going to have to be something different done. And I understand that that's due to the changes to the Cooperative and Benefit Society Act in 2014, which means that the situation back when the co-op was set up in 2008, it's not possible to do that again, because it's not it's no longer can be set up in the same way, because it doesn't meet the criteria, and that the FCA are actually looking again at that, at updating the Cooperative and Community Benefit Society Act. So again, it's good to have participation, but it absolutely is not on an equitable basis. Now that people in the community as well have a far greater understanding, almost 20 years down the line, there will be demands that what's given is on a much more equitable footing. There's a whole spectrum of community participation, which it's not black and white, it's this or it's nothing. There are opportunities, if there was collaboration and if there was good discussions going on with community groups, which a number of agencies have been trying to do, but not getting the engagement back from developers. And on the onshore sector deal that Scottish Renewables and the Scottish Government published in September 2023, it talks about by the end of 2024 we will look for opportunities where we can take a collaborative approach to coordinating community benefit funds with developers, owners and the local communities of neighbouring developments where there are common and overlapping areas of benefit. And further it goes on, we will engage with key stakeholder organisations during the pre-planning application phase of projects to highlight community shared ownership opportunities and provide community bodies with sufficient time to investigate these opportunities. So there are certainly statements being made by the industry and representative bodies of the developers that there's a desire to take that forward. And Skye is the ideal opportunity to do that, where we have multiple projects overlapping multiple areas happening at the same time. But we're now into 2025 and it's been really difficult to get any of the engagement, the collective engagement with developers over the last 3 years to do any of that.
May I just have 1 second?
And yeah, just one last point would be that it would be useful to hear from Mr. Blackett what the justification is for the different treatment of local shareholders of the Isle of Skye Renewables Cooperative versus the ordinary shareholders of the Ben Aketil Wind Energy, and why doesn't the cooperative get the same position and status?
I think I'm going to give Mr. Blackett an opportunity to respond to that and then move on to the next topic, if that's...
Okay, and I think on the definition of shared ownership and whether it fits with the guidance, I would argue that absolutely does. The good practice guidelines, this model fits the principles of them. I think Ms. Clyde made a reference to a document, but the part of that document is not about shared ownership as a generality. It's about a specific form of joint venture shared ownership, and there's no one's claiming that this would be a joint venture. So that it wouldn't be expected to meet those requirements.
Is that required?
Yes. Sorry. That reference is to the Community Energy Scotland document CD 15.20. So those criteria are for credible joint ventures, and that this is not a joint venture. But it definitely meets the wider guidance on shared ownership. I guess on the point about looking for alternative models, that would be an option, but there's a model here that works. So I think the developer, the applicant's decision to go with that model, whilst making changes that will be required to make sure it remains legal and appropriate, but essentially a similar model seems to me to make a lot of sense. Rather than to risk something that doesn't work, we go with something that's proven. In terms of the treatment of the court members relative to the company shareholders, there's two parts to that. One is that they're not doing the same thing. The investment happens at the point that the project is already going ahead, whereas many of the risks in the onshore wind sector happen in the development process. Does a site stack up and is it feasible? Does it get consent? And all these decisions, there are huge risks in there. which the court members are not taking, the applicant has been very clear that they don't think it's appropriate to involve community members at that level of risk before there's some clarity and certainty that a project will proceed. And the other thing that's happened here in terms of Energy for All's involvement, they've looked into people's preferences and done survey work on it and concluded that people's appetite for risk is you're willing to take some risk, but it's not unlimited, not unlimited risk, which is why they came up with a model where some of it's like a guaranteed return and some of it is related to equity. So if you like, they're almost putting a floor. There's still some risk because I guess the company could fail, but they're almost putting a floor on the risk whilst allowing a share on the upside in terms of potential benefit. So they are different, but they're doing different things. And it seems to me it's appropriate. These are appropriate differences given that context.
All right. The next point was about the alternative. Mr. McLeod made the argument. Well, perhaps I should let you make it, Mr. McLeod, about a wind development could be under an alternative system where the community carried it out.
There was an endless numbers of different alternatives that could be looked at, but certainly a number of communities, and actually they're quite far on in their thinking and their plans, particularly on the Isle of Lewis, where there are far greater opportunities potentially for collaboration because of the level of community land ownership there. We now have 75% of the Western Isles in the hands of the community, and they're using that to great effect by working collaboratively, communities together, working on projects in order to deliver a number of different things. One is a wholly owned community project that they're going to develop onshore, but also negotiating collaboratively across those different projects with the offshore wind developers as well, in order to make sure that they can maximise the benefits that they get back for their communities. And that collaborative ability to do that, because they're community landowners, is giving them much greater benefits than we've been able to see or get here on Skye. So some of the communities locally, some of the development trusts are quite keen to take forward community projects, and we've looked at how that can be done. There are some challenges because rocks and fits have been removed, and on the Isle of Skye we don't qualify for contract for difference. However, we've looked at a model whereby even with 100-metre high turbines, it would be financially viable. Not as viable as it would be, or not as profitable as it would be with rocks and fits, but it would still be financially viable. And communities, I guess, are at a benefit because they don't have shareholders who are looking for returns, and therefore they can spend the first 5 years building up the reserves, making sure that the reserves that are required by the banking facilities are fulfilled, and then generally start to take community benefit out after that point. And therefore they can be quite resilient actually in a recession or in difficult times, because they don't necessarily have shareholder returns and return on equity percentages that shareholders are looking for year on year, so they don't have that call on cash. But we have looked at, and it can be done with 100-metre high turbines. Therefore, there won't necessarily be the same level of return if they had subsidies or if they were larger turbines, but these could be delivered, therefore allowing money to remain in the local economy. Because I guess certainly looking at the last set of accounts for the developer, it looks like, although it's Nadara that's taking forward the project, that ultimately it's a a fund in the Cayman Islands that is the ultimate beneficiary of the funds, whereas if it was wholly owned in the community, all of the money would remain locally in Skye, and we would have that circular economy, just transition that's being looked for, that we're not seeing if it's extractive, and the funds are all being extracted outside of Scotland or the UK.
But you'd also have, as Mr. Black pointed out, the community would also have the risks.
That's correct, but what we've found, particularly with the community projects in the Western Isles, that there are a number of banks who have been hugely supportive and have acted as a very expert partner in the whole project. They've obviously done that because they're getting a good financial return on projects that are seen to be relatively safe and secure, otherwise they would not be committing to them to the level that they are. In some cases, the banks have actually funded up to 100%, because they see the benefits of working with the community, and it's good for their social values as well, that they are participating in that. They're doing it at commercial rates as well, but it has the benefit of them making the commercial return, but also getting the benefit of the environmental and community and social value from that.
I'll give Ms. Black an opportunity to respond, and then, unless there's something specific, we'll move on to the next point.
Okay, I mean, I think as far as the community ownership model is concerned, I guess in terms of the decision that the recommendations that you need to make, sir, is there's not an alternative model on offer, so there isn't an alternative project. I would go further and say there's very little prospect of such an option emerging, and maybe I can explain why that's the case. So for such a project to come forward would require the community to raise significant funds, and first of all to either purchase land or secure some sort of land agreement, then to develop the project, to design that alternative scheme and pursue a consenting process, and all of that would take several years and a substantial investment, and as you pointed out, a substantial risk, and then to construct the wind farm itself. So I guess that's a lot of work, and a lot of really significant hurdles to overcome. I would suggest the land one is probably the biggest of those. I would also say that there are challenges with the proposal to have smaller turbines. Manufacturers are generally increasing the size of turbines because that makes sense from an engineering and financial perspective. That ultimately leads to downward pressure on generating costs and therefore ultimately lower electricity bills, which is clearly an important element of energy policy. If that sort of model worked, I would expect the wind farm developers who are experts on these matters to be pursuing it, and they're not. That's not just what's not happening in the market just now. All of that said, community ownership does have a role. I'm not saying that community ownership is not a good thing. It absolutely is. It's just that there's not a project here to be considered. And it's also, I don't think it's reasonable to compare a community ownership project with a sort of commercial wind farm development. That almost all of the electricity generating capacity in Scotland has been developed by the private sector. That's around about 99%, it's not quite all, but almost all, with about 1% being in community ownership. So it does have a role, but it's not reasonable to consider it to be a model that can deliver the Scottish Government's objectives in terms of energy policy, or indeed the UK Government. It's just the scale is not there to be able to do it. So if if the objective is to secure some community ownership, really the only viable way of that happening, at least in the short term, and I mean the next decade or two, is the proposed shared ownership model that will be part of this project, the co-op-based approach. But there was also a matter about the ownership of the applicant. Should I deal with that as well?
Yes.
So I guess it was presented as the applicant being, I think the phrase was used, ultimate beneficiaries. So it's probably worth just giving a bit of background to the position of the applicant. So Nadara is owned by the Infrastructure Investment Fund, which is a fund managed by JP Morgan, and that's a fund set up specifically as a mechanism for investing in big infrastructure projects like this. And so the nature of those projects is most of the investors in that fund are pension funds, including public sector pension funds as well as private sector pension funds. So therefore the ultimate beneficiaries of it via that fund are the pensioners, or not the pensioners, the current employees who will become pensioners in the future. And it will probably include some people in this room. We just don't know it because there are many steps between making a pension contribution to where it's ultimately invested.
Unless there's something specific to come back on, I'll move on to the next point. Are you happy to do that?
I'm just going to say that the projects in the Western Isles have been very successful, and that there's a lot of knowledge built up as well with individual project managers who have delivered those, and they're looking at further expansion of those. So there is, and there is, as I said, it's not a binary, it's A or it's B. There's a scale, and there are opportunities to somewhere in between on that spectrum as well, for it, rather than it to be a developer or a community, that they're somewhere in the middle. But in order to do that, there has to be meaningful discussions from a very early stage. I think the Scottish Government document talks about pre-planning. Well, here we are, post-planning, and the whole shared ownership aspect of things hasn't yet been bottomed out for this project, or many of the others that are in the programme. And I've been talking to developers over a number of years, and it's very difficult to get any detail as to what there's a promise of there will be some community share ownership, but it's nigh on impossible. So it's been impossible so far to get the detailed contractual arrangements around that in order to talk to the banks about getting the funding in place. And there are a couple of banks that are interested, but it's a bit chicken and egg in the sense that without a contract it's difficult to get that commitment, and vice versa.
I think it's just early days. I think as I said when I mentioned the applicant's view on these matters, that they don't offer the scheme, they don't offer the shares until the project is being constructed, so that it doesn't become live until it's definitely going ahead when it's commissioned. But that's not to say that the work is left until then. There has already been some initial work looking at the options, and that will ramp up over the time between now and the project going ahead if it's consented.
So there's been discussion with potential shareholders.
Energy for All have started work looking at how a new scheme might work to deal with some of the issues that were raised earlier, and that there have been some discussions on Sky, yes.
Right. The last question relates to, or the second, sorry, unless there's something you want to come back on, or is there anything specific? Yes, of course. We haven't been going for 2 hours yet. We'll take to 25 to 12. Intended as a, it reflects the test in policy 11C, I think, in the National Planning Framework, fourth National Planning Framework, which requires development proposals will only be supported where they maximise net economic impact, including local and economic, socio-economic benefits, such as employment, associated business and supply chain opportunities. So this was really just an opportunity, I thought, to sum up your positions. So I would give, I think I'll give Mr. MacLeod an opportunity to speak, and then Mr. Black an opportunity to respond on that. And I think that would, unless there's anything else anyone wants to raise on socio-economic benefits that haven't put down in the questions, I think that would bring this to a close. So, Mr. MacLeod.
So net economic impact is, and the effect of that as well, is interesting. Clearly there is economic impact from the wind farm and the Ben Aketil wind farm. But the question is, how does that relate to the local economy? And is it the net economic impact on the local economy that we're looking at? If it is, then we have to look at how circular is that economy, or are we looking at something that's quite extractive from Sky's economy? And I would argue that the current model that's being put forward, and the traditional model that's being put forward in terms of the way that it's set up at the moment, is quite extractive. It was disappointing to note even that just recently the registered office of Ben Aketil wind farm is not even in the Highlands anymore. It was in Inverness and it's now been moved to Edinburgh, which again moves us away from that localness, if even you consider the Highlands to be local. The question has to be, Mr. Blackett mentioned, community benefits work. For whom does it work? Does it work on the current model for the developer? But would the local community consider that it works? It's been described as being crumbs off the table at times, that the developer chucks something at the community so that they can then make the whole PR campaign work in terms of community benefit. But it's the scale of that and whether that is sufficient to compensate the island for its loss. And 200-metre high turbines will have an impact, a significant impact on the island in many ways, whereas a community-owned or a partnership model of working could return more significant benefits locally from smaller turbines with less visual impact, which is less likely to do damage to tourism. And I guess the other point I would mention is, in recent years, Sky's had a huge impact from social media, and that the speed with which communication and data moves is so much faster. And if we have a period of 5 or 6 years of road disruption on Skye from the cumulative impact of all of these developments, our tourism industry may very well be dead. The speed with which that information will get round, don't go to Skye for the next 5 or 6 years, could have a devastating impact on the businesses that are located here. So in terms of net economic impact, I would have to argue that there is a very negative net economic impact locally from the Repowered project at Ben Aketil, particularly when we take into account the cumulative impact of all the other developments going on at the same time.
Could I just add an anecdote from the break? While it's not directly impacted by this development, I was just discussing with somebody who lives on Torrin Road in Broadford that she's recently had her house valued. Torrin Road is where they're planning to put one of the worker camps for building the Sky OHL, which of course is essential for this project to go ahead. She had her house valued and she was told by the estate agent that the value of her house is now considerably lessened because of the proposal to build the workers' camp on Torrin Road. So as an impact, an example of the cumulative impact that all these projects are having directly on somebody who lives on this island. I think we can see that replicated across the island if all these projects go ahead.
Spracket.
Yes, my position on behalf of the applicant is that this project will maximise net economic benefit. And I think in order to explain why I think that, I think it's worth maybe unpicking what does that mean. Because I guess unfortunately for decision makers like yourself, that the guidance doesn't give a detailed definition of what it means. And therefore, the industry has been engaging with government to try and understand really what the aspirations are behind that policy. And that's led to a number of initiatives, including the onshore wind sector deal. And, more recently, Scottish Renewables has published guidance that takes us a step further, and it really highlights the sorts of actions that can be taken to maximise those benefits. And in both cases, these things are seen as there's kind of four main themes, and they are the supply chain development, skills development, community empowerment, and that includes taking account of sort of community benefit and shared ownership, and sort of environmental enhancement, so the project taking place in regard to that and the socio-economic consequences of that. And this project is addressing all four of those themes. So we have commitments on the use of local workforces and suppliers. And that includes very practical things like there's already a registration system for potential suppliers on the website. There's as we've already discussed, the commitments to community benefit and shared ownership. And it's really on that basis it's reasonable to conclude that the applicant has made efforts to engage with the intention line behind that policy, which is to make sure that there are benefits to the local economy and community from the project.
The policy is to maximise, not just to provide benefits or net benefits.
Yes, I think probably the authors of that might look again at the language if it was still at draft stage, because it's difficult then to sort of define that further. I mean, I think that's why all of this government and industry interaction on the deal and on the guidance has taken place, and I guess it's interpreted the word maximise as to take action, to increase what it would otherwise be if you didn't take action. So I guess that's how that particular word has been interpreted. And as I said, there's those four themes for the sorts of actions that you might take for it to be reasonably concluded that you have maximised.
Right. Unless Spirit come back, do you want to come back on anything?
No, I don't think I've got anything else to add to that.
So we'll conclude this session. We've only just had a break, so I think we should move directly into the policy session. I think we've got, it's 11:45. if we aim to finish by about 1:30, hopefully that will give people time to make arrangements to get away, have birthday parties, and so on. So I'll just give people a moment to get settled. Thank you, Mr. Blackett, and thank you, Mr. McLeod, too, and the others who took part. So the first two questions in the policy agenda are about agreed matters. Essentially, it's a question to SWIG about whether they agree with those sections that are set out in the statement of agreed matters between the council and the applicant.
I'm afraid we don't. I should have explained Mr. Kelly's not able to be here, and I'm sorry about that, but I will do my best to provide policy, in inverted commas, evidence when you require it. But taking your question, the statement of agreed matters was not circulated early enough, for whatever reason, to allow a detailed response in writing by SWIG. So my sort of baseline position is that I don't agree with its contents. However, there are, of course, bits that I do agree with. Rather than take up your time with that today, may I suggest that I deal with that also in closing submissions, or in a separate appendix to my closing submissions.
I guess I was going to suggest actually that people should indicate if they wish to deal with things in closing submissions in this session. But given that we've got Mr. Bell's expertise, Mr. Fitzpatrick, and yourself, I thought it would be useful to run through the questions in any case, just to check what people had to raise. But if there's something that is ultimately more complicated or for submission that can be dealt with in submissions, then I'm content to leave it with that.
I mean, I don't want to appear obstructive in relation to the statement of agreed matters, but it's quite a contentious, widely framed document, and it contains a lot of rather broad, sweeping propositions which you seriously wouldn't expect a community to agree with de plano. However, with a little bit of parsing and a little bit of explanation, I think I can make sense of it for you, and you can see where the community stands on that matter without going into massive, great length.
So can I add to that? Insofar as Murmanford's not intending to deal with the statement of agreed matters today, and rather address it in his closing submissions, we haven't yet agreed a timetable for the closing submissions, but I'm assuming that he will be doing that in advance of the applicant's closing submissions, so that at least the applicant has notice before putting in their own. Otherwise, I would be nervous that he didn't address it today, because we wouldn't have notice of his position prior to doing our own closing submissions.
Yes, I think it's standard practice for the applicant to give closing submissions last.
Yes, I agree that's a reasonable request, and certainly I'm happy to honour it in respect of that matter at least. But the applicant will have the last word anyway. In terms of closing submissions, I think we would be looking at dealing with them after the ornithology session, which we've set in August. So that may be some time away, but I think we'd be looking at getting closing submissions quite shortly after that, and a response from the applicant quite shortly. So I think the objectors first, SWIG first, then the council, and then the applicant. But I think we can arrange a timetable for that later on, given that there's the ornithology session in August.
Thank you, sir. I'm obliged by your clarification that you wouldn't be expecting closing submissions on everything other than the ornithology, that they'll all come in at the one time.
That makes sense, and certainly although we're not involved in the ornithology submissions, I think your idea of having SWIG and any others, then the council and then the applicant is the usual order and makes good logic. And given that SWIG are involved with the ornithology session, then the timetable really organises itself, and it should run from when the ornithology session is completed. But no doubt parties can be working on their closing submissions on other matters in the meantime. So certainly the councils will be ready fairly soon after that ornithology session.
So the next question in this agenda is on landscape and visual effects. The first one on the issue of whether landscape and visual effects are localised in terms of policy 11E2 of the Fourth National Planning Framework. Just if there's anything that can assist me in understanding the term localised in terms of the evidence that we've heard. I'll start with Mr. Bell.
Thanks, sir. I think firstly our position is that the landscape character and the visual impacts that would arise would be localised. You have the landscape evidence that was heard earlier in the week, so I don't propose to go into that at all. I think whilst the term is not defined in policy or guidance, we do have the insight now of a number of post-NPF4 Section 36 decisions. There's two that I think are particularly helpful. CD 12.26, which is Cleansaid, a 16 turbine development at 200 metres to tip height, which was consented by the Scottish Ministers, no objection from Highland Council, and also a scheme called Bunloin, that's BUNLOINN, which is CD 12.23, 10 turbines at 200 metres, again consented by the Scottish Ministers, no objection from Highland Council. In the both of these decision letters, certainly in Cleanside, the effects went out to 12 kilometres. Landscape and visual were deemed by the ministers to be relatively localised. In Bunloin, they went out to largely 12 kilometres with none greater than 14.7, again considered to be largely localised. So I think these are helpful comparators about the spatial extent, and you don't need to look at the facts and circumstances of those schemes, but they are helpful in terms of how the ministers have taken a view on localised.
Can we deal with that in two parts? And I'll have a look at those particular cases. I think the first one is one of Mr. Fitzpatrick's, in fact. But in our submission, it's interesting that in both cases they were found to be relatively or largely localised. The policy test is whether they're localised or not. And secondly, our view is that they are not localised in this case, and you have to consider it on a case-by-case basis. But I'll pass over to Mr. Fitzpatrick to summarise our view on that, although you will have heard some of the evidence, or all the evidence, effectively already.
Yeah, I mean, our reasons are fourfold. It's the impacts on landscape character beyond the moorland interior of Central Skye, but in comparison, the proposed significant adverse landscape effects extend to the regionally distinctive landscape and seascape of Loch Bracadale, including its small coastal crofting landscape. These effects aren't really considered localised by the planning authority. as set out in the report and as set out in Andrew Daly's evidence. The geographic extent and nature of the in-solis and cumulative visual effects, including on several place-based receptors. We haven't considered them localised in this instance. Also, these significant visual effects also impact the perception and experience of the character and special qualities of the regionally designated Northwest Skye special landscape area. So that we don't consider that to be a localised effect. And also, just to add to that, the agreed position is that the alternative 180-metre turbines aren't really effective in mitigating any of those effects, and therefore appropriate mitigation hasn't been applied.
So I wasn't going to go into the evidence. Sorry, Skill.
Yes. May I respectfully ask you to, when you're thinking about this, refer to Policy 11, E2, and remind yourself that the word localised is talking, or qualifying the noun impacts. So it's not a phrase which gives a blessing to the entire development in all its manifestations. It's simply a measure of the impacts which may be derived or predicted to come from the development. The same thing you should do with the policy, of course, is just apply the normal rules of construction, of which the first and most important is to apply its meaning in plain English. This is not a defined term in the glossary to NBF4, and whilst Mr. Bell's quite right to instance a couple of wind farm applications where there have been a consideration of the term, and those are not the only two by any means. With the greatest of respect, the Scottish ministers could hardly be considered to be impartial in this matter, and their interpretation will not bind you and shouldn't influence you, because the facts on the ground are different in every case. It says, as you can see from Policy 11, sorry, I've lost it now, where impacts are localised and or appropriate design mitigation has been applied, they will generally be considered to be acceptable. So that's impacts, and that's as far as it takes in looking at that word. Overall acceptability is a different question, and of course you have to take in how would I put it? I don't know, I think I'm just going to leave the rest for my closing submissions, the overall geography of the matter. Just got a microphone on, maybe. No? I'll try again. Is that better? Yes. Thanks. Obviously, you've taken into account the overall geography of the location and so on, so I don't want to make a landscape submission now. But we don't agree, for the avoidance of doubt, that this is a project which will have localised impacts. And you heard Ms. Platt, particularly on the matter.
Sir, I think some of the points raised seem to go into the next item on the agenda about acceptability, and I think there's a strong overlap. We'll come on to that. But I think, I'd agree with Mr. Campbell, it's the plain reading of the word localised. It's predominantly spatial extent. So our position is that the significant landscape character effects extend out to 5 kilometres. The council seems to be taking a position that that is not localised. But you've got the evidence of both parties on that, and we can see from those decisions that that's clearly within the spatial extent that the ministers have considered localised would extend out to. I'm not saying you're bound by that, but I think it's a helpful guide. And Also, in terms of the significant visual effects, they would extend here out in Ms Anderson's evidence to 12 kilometres. And again, we would say that is localised. The matter of the SLA is a slightly different point. That doesn't go to whether matters are localised, but it may go to acceptability, and that brings another policy point. There are clearly other factors that go into judging acceptability, but that's on your next question.
Well, I think perhaps you can deal with the next question, and the judgment, yeah. Well, how do we judge acceptability?
I think firstly I would highlight that NPF4 is clear in stating that there is an expectation that there is likely to be significant effects from some forms of renewable energy. I think the word generally acceptable in the NPF4 policy is important, because that indicates to me that there may be occasions where localised impacts may not be acceptable. So I think it's important to recognise that. So I would say the first step is to look at the spatial extent. Are they localised or not? And then to also look at the sensitivity of receptors that could be affected and the degree of impact. And I think in looking at that point, it's important to look at the onshore wind policy statement, which was published at the same time as the finalised NPF4 became available. And within the onshore wind policy statement, section 3.6, there's 5 points that I think are helpful to note in informing how you might judge acceptability. So in section 3.6, it confirms the government target of 20 gigawatts of onshore wind by 2030. It states that this will require taller and more efficient turbines, and it has underlined this will change the landscape. Thirdly, we have a clear reference that development plans are to seek to realise an area's full potential. And we know from NPF4 that wind energy is to be supported in all areas, except in relation to national parks and national scenic areas. And the onshore wind policy statement states that outside of these areas, assessment criteria has been updated, including stronger weight being afforded to the contribution of the development to the climate emergency, as well as community benefits. Now, we have lodged one decision, which is relatively recent, May this year, called Ladyfield, which is a Section 36 decision for a project within Argyll and Bute. And paragraph 78 is helpful, which sets out that the Scottish ministers acknowledge that the proposed development will have some significant landscape and visual impacts, but overall these would remain relatively localised, with the majority occurring within 10 kilometres of the development. And the ministers go on to talk about the scheme in various ways, but it illustrates the point in that case where you're not affecting a national designation, you have generally localised impacts, and it should follow that if there are no unacceptable impacts on receptors within a localised area, then consent should be forthcoming as a general approach. I think the other point that would be helpful for you is to look at the question as to whether there has been appropriate design mitigation. And one decision which I think is helpful in looking at that is the Blairgower Section 36C. Again, it's an Argyll and Bute case dated August 2024. And at paragraph 76 in that decision, which is CD 12.31, the ministers state that they're satisfied that the development has been through a thorough design iteration process which has taken account of all the environmental constraints, and the wind turbines have been sited to take account of landscape, visual unity and habitat sensitivities. So appropriate design mitigation is not just, I would say, taking one step. It is a process, which for this project is set out clearly within the EIA report. And lastly, I think a very important point is recognition of repowering. And in the onshore wind policy statement, paragraph 5.3.1, it references repowering, and at paragraph 5.3.6, yes, you got some water. And at paragraph 5.3.6, sorry, 5.3.8, it sets out that other major advantages of repowering include the opportunity for co-location with other technologies such as battery storage. And that is clearly a benefit that this project brings. And there are other aspects within that section on repowering, which I won't go through because of time today, but I would recommend that they are taken into account. Thank you.
So can I respond to that? Fairly briefly, I hope. Firstly, it's clearly recognised that all commercial scale wind farms will have significant effects, and there's no dispute between the parties as to that. Secondly, notwithstanding the references that Mr. Bell has referred to, the Scottish ministers have still affirmed they're looking for the right development in the right place. Now, this is potentially the right place for wind farm development because no one is complaining significantly about the existing Ben Aketil development. The question is whether this is the right development for this place. And whilst regard can be had to other decisions, it is a site-specific decision. To answer your question directly, given that the existence of Policy 11 dealing with renewable energy, in short term, say that if the proposal satisfies Policy 11, it is highly likely to be acceptable under Policy 4A. Policy 4A is very broad in its context and deals with a large number of developments, whereas Policy 11 is dealing with renewable energy developments and lists in significant detail those factors that you should have regard to, particularly under criterion E. If having gone through Policy 11, you're satisfied that there is, and the equivalent island-wide local development plan policy, which we'll come on to, those are the factors which really coincide in large part, albeit not framed in precisely the same way that Mr. Bell was illustrating by reference to the onshore wind policy guidance, that you need to take into account in deciding what is acceptable and unacceptable. I don't think there's really any in-principle dispute between the parties on that. We might phrase it in different ways, or certainly between us and the applicant. But that's, in answer to your question, it's really having regard to those factors set out in Policy 11.
Sorry, just in terms of Policy 11, so having regard to those factors, but there's not an actual test in Policy 11 except perhaps in 11C.
No, there isn't, but it's your question was how to make a judgment of acceptability. Our answer is by reference to those factors in Policy 11. As to the outcome of that judgment, we'll come on to, no doubt, under other headings, but that's the answer to your question.
Mr. Campbell?
Yes, unsurprisingly, I agree with Mr. Finlay. Mr. Bell's compelling journey through those other decisions has left him for a point where he's lurched from the application to overall acceptability without necessarily dwelling on the criteria and the tests in policy 11, with respect to him, he goes too fast. He gets to overall acceptability too quickly without looking at the steps that he has to take. So I won't waste your time. I agree with what Mr. Finlay said about policy 11. And your question is, how do I get to a judgment about acceptability? Well, NPF helps you, NPF4 helps you, but you've also got to think about the overall geography. You've also got to think about Skye as a unum quid and how it works, and you've heard from Mr. McLeod this morning. So there are other factors apart from simple visual, landscape and visual considerations.
But you accept that the requirement in both the onshore policy WIN statement that Ms. Bell referred to, and the requirement to reach 20 gigawatts by 2030, that's a consideration in acceptability, is it?
Well, it rather depends on whether you take into account the offshore consents or not, whether that 20 gigawatts is almost achieved or whether it's still an outstanding target. With respect to Mr. Bell, the onshore wind policy statement is out of date now. The energy statement, the energy strategy is still a draft. So we are operating in a bit of an intellectual vacuum as far as targets are concerned. 20 gigawatts is the political target, certainly at the time those documents were published. But you've got to take account of whether or not it's embracing offshore generation, or is it only onshore generation? How have we progressed in getting to the towards 20 gigawatts? And of course, any wind farm, consented wind farm, will contribute to a target. There is no cap on a target, as ministers tell us. Once we get to the target, we just have to keep going. So in a almost philosophical sense, it's meaningless, because it's just build as much as you can. And the key test for you is sorry, it's a cliche nowadays, but it's the right wind farm in the right place.
Yes, sir.
So I'm just answering your question about landscape and visual effects. So I'm not going into the other aspects of Policy 11 yet. That is coming. So I was restricting my response to landscape and visual considerations and the approach to judging acceptability of those. And I do have things to say on the group's position on wider energy policy, but that will be later in the agenda. I'll hold back until then.
No, really, but my point was simply you wouldn't consent to development with the landscape and visual effects of the proposed development unless there was some kind of offsetting factor. The offsetting factor must be something else. So it must be the policy support, or and the reasons behind the policy support.
Yes, it's in Policy 11, it's in considering the impact significantly be placed on the contribution of the proposal. And here it's a nationally important development. And when you look at the contribution, we need to look at not just 2030, but beyond that. And there's a very important document that shows us the expected contribution of onshore wind to 2050, which is just published this year. And also the contribution will be realised by its the delivery of the energy by the consented Skye Reinforcement Project, which provides an upgraded overhead line to Fort Augustus. And this is part of the project this project is part of the need case for that development, just consented. And the grid connection date is pre-2030. So this project can make a near-term contribution to those targets which remain, as we know from the recent decisions, a priority of the Scottish ministers.
Mr. Campbell.
The trouble with that approach is that it isn't a balanced planner's approach. Mr. Bell's not recognising that there may be something on the other side of the scales which would cause a decision maker to draw back from recognising everything he said. And of course I accept what you said. but the scales have two pans, and he's put everything into one side, but he's not recognising in his submissions to you that there are other countervailing factors which we've attempted to articulate for you. We're still on your question, and I think you mean overall acceptability rather than simply landscape and visual acceptability.
Well, isn't that what 4A has to mean in these circumstances? It has to be overall acceptability.
Yes, it does. Yeah, I just was checking that that's what the question meant. Anyway, I think I'm in danger of repeating myself, and I don't want to do that.
The next question was on 4D, and Ms. Bell wants to come back on that, but I think I have party's position on that. 4D, just to confirm that's not relevant. Is that not relevant, notwithstanding the Council's position that some significant effects on North West Skye Special Landscape Area and the Objective's position that there's also effects on the Greshenish Special Landscape Area?
So can I start on this? Because in our submission it is relevant, because there are effects on, whilst we don't suggest an effect on the integrity, we do suggest significant impacts on the qualities for which that has been identified. And in our submission that's clear, and Mr. Daly identified significant impacts on two qualities. There may be a dispute about his addition of crofting qualities, but dynamic coastline in both a solus and cumulative basis. So 4D is relevant. It's a factor for you to take into account. My understanding, although Mr. Bell will no doubt speak for himself, is that that's an agreed position. But
yes, I'd agree with Mr. Finlay that policy would be engaged because of the effects on the SLA. I think it's a singular impact on one special quality, which is set out in the statement of agreement, rather than a number of special qualities being affected. And the policy does tell us that if there are significant adverse effects on the integrity, then they can be clearly outweighed by benefits if they are of at least local importance. And in this case, the development is of national importance. So there is a balancing consideration to be taken into account if there are such effects arising.
Back on that briefly, the trouble with drafting, and it may be a drafting error, is that D2 only deals with impacts on integrity. It doesn't deal with impacts on special qualities. Which is has all the hallmarks of an oversight, but one doesn't know what the Scottish Government meant to happen in that case. So it's a matter that we will comment on, but it's clearly not going to be decisive in the outcome. But it will be an important matter for you to weigh in the balance. And at this stage, I'm not going to descend into the merits, but there's no clear let out under D2, but those are obviously matters of importance to be counterweighed with any conflict with D1.
I agree. I don't think I have anything to add.
And is there anything further on policy 57, Allied Local Development Plan? Is that relevant to the proposed development's effect on the special landscape areas yet?
I think I would say NPR4 would prevail, given there are some conflicts with policy 57. I think you can rely fully on the NPR4 policy position there rather than placing weight on policy 57.
So yeah, I know you come on to a test of compatibility, but I think if you were to apply the test that you proposed, you wouldn't result in any different outcome whether you apply policy 57 or MPF4. So I don't think there's a compatibility issue, so it is relevant, but it effectively doesn't take you any further than policy 4 and MPF4 in any event. They're broadly compatible, and when we come to the test on compatibility, in your question 7, our answer to that will be yes.
I think there's a disagreement here because I think you could get a different outcome, because the wording in policy 57 is that development will not have an unacceptable impact. Now, where the council draws the line of acceptability is not known, but we know from NPF4 policy 4 that a development could have an impact on the integrity of a designation, and that's quite a high test. I think there would need to be very significant impacts to undermine the overall integrity of a designation. But even if that were to be so in this case, then the policy allows for benefits of more than local importance to outweigh such an impact. So I think you could get a different outcome in looking at the application of this policy. And I think there is a case, Shepherd's Rig, which was one of the very early post-NPF4 decisions, where a reporter changed their mind because of the application of this policy in relation to a regional scenic area. So I think it's been a design change here to allow for deployment of wind energy. And I think it's an important balancing provision that this policy brings in, which is not in policy 57.
I would disagree with that. I think Mr. Bell is creating an issue which doesn't exist and will not have a practical implication. So I'll be short. Policy 57, dealing with features of local or regional importance, says that they will be allowed if they don't have unacceptable impact. The judgment on unacceptable impact we've been through already. It can take into account a large number of factors, which can include all those factors set out that Mr. Bell wishes to rely on, as just referred to. So I really don't think there is an incompatibility issue. But certainly from the Highland Council's position, you're not likely to lead to a separate outcome. Perhaps if Mr. Bell is correct, you could lead to a different outcome, but I think that's unlikely.
One very final point, the appendix which policy 57 relies on for its further application states that the policy framework for the approach to SLAs will be SPP. And that would have been SPP as of April 2012, so that's what it directs the decision maker to apply.
That clearly has to be read in context, I would say, but any reference to national policy will be an updating reference in that regard. So I'm certainly from the Highlands Council viewpoint, there's no suggestion that you should be applying SPP, even when considering policy 57. That you have to read these policies when they are come out in sequence with changing national policy with a certain degree of common sense and practicality. And it's clearly a reference to the national guidance at the time, which was SPP. It's now changed. So I really, I'm doing my best to try and agree and diffuse disagreement with Mr. Bell, but I can only go so far in that regard. It's a matter for you ultimately.
Mr. Campbell, we've heard evidence on cultural heritage. I've mentioned three relevant policies there. Is there anything that we need to say about policy? Well, actually, there was one question I did have about policy 7, 7I as compared with policy 7C. So policy 7I is about gardens and designed landscapes, and it says that development proposals affecting nationally important gardens and designed landscapes will be supported where they protect, preserve or enhance their cultural significance, character or integrity, and will not significantly impact on important views to, from and within the site or its setting. So if something has an impact on the setting, then it's not supported by the policy. But the policy doesn't say that, and essentially it doesn't say that there's a policy restriction, as far as I can see. Perhaps that's one for you to address. Whereas perhaps a comparison with policy 7C, where in the last sentence it says development proposals affecting the setting of a listed building should preserve its character and its special architectural or historic interest. So it's a direct requirement.
So I know that the difference in the wording in our submission, if there is a significant impact on setting about which there is clear disagreement, but if you find there is a significant impact on setting, given that the garden design landscapes are a statutorily identified and protected feature, then there would be conflict with the policy. And to interpret policy 7 as providing a significantly different test for listed buildings and say lesser protection for garden and design landscapes and listed buildings would be contrary to the general approach of Hess and would mark a significant policy change. So for those reasons, in our submission, the intent of the policy is clear. And if one was to go back to the policy outcomes and policy intent, it's to protect and enhance. And if you find that there's a damage, that is clearly policy to the policy intent. And in our submission, the failure to accord with policy 7I would be a significant counterbalance to those factors in favour of the development.
The reason I ask is simply because elsewhere in NPF4, when that kind of phrasing is used, it appears to have a neutral outcome when it doesn't comply with the policy. But I suppose I take you, but perhaps Mr. Bell, do you agree with Mr. Findlay on this?
I think the policy wording is different, and that is a material factor when you're interpreting and applying the policies. I think also NPF4 is clear on page 98, the plan needs to be read as a whole. So whilst there may be, it's of course your judgment based on the evidence that's been expressed this week, but that is a factor to take into account, but also alongside the position of Historic Environment Scotland and the other policy provisions within NPF4.
Mr. Campbell, you don't have anything, no? You weren't involved in cultural heritage sessions, so no?
What's the same? No business saying.
Right. Right, okay. So I'll move on with part of submission. So the next question is about biodiversity, and this was really simply to pick up a point, but simply because I think I need to report on this, and I wasn't completely clear from your report, and I'm not sure I was completely clear from the IA what the answer to the policy test in policy 3B is, where it requires not only conservation and restoration, but also enhancement of biodiversity. sorry, Mr. Bell.
Yes, thank you. It is a matter that is addressed within the Outline Habitat Management Plan. The planning statement that was produced as well deals with it at section 3.9, and it sets out reference to the various aims and associated objectives and the measures for significant biodiversity enhancement. That would be secured by way of a standard condition, and that is the approach that has been taken on other Section 36 decisions. There remains no finalised guidance on significant biodiversity enhancement, and we still have the draft guidance of the Scottish Government, which gives flexibility as to whether you use a metric or a qualitative approach. But there's been no issue raised by Nature Scot or the Council that what has been proposed has been inadequate. So I don't see any conflict with Policy 3 on that.
No, I just wanted to be clear about what I should write in my report, and you've directed the document.
I would say planning statement, section 3.9, page 42, and the Outline Habitat Management Plan, which we can get a reference for.
The next question, the rural development policy. This was something raised in Mr. Kelly's statement, I think. So I just wanted to understand whether that's something I should take into account. This is the rural development policy in NPF4, policy 29.
If I go first on that, it's not referenced in the Statement of Agreement as a relevant policy. I've never seen it referenced in any of the 30-odd post-NPF4 Section 36 decision letters. The only point of relevance could be paragraph A, which sets out that proposals that contribute to the diversity of the rural economy and communities and various land use types includes essential infrastructure. And this development is defined in NPF4 as essential infrastructure. So it would satisfy paragraph A of policy 29. I think the other aspects of the policy are of no real relevance.
With respect, sub-policy B, 29B, begins development proposals in rural areas should be suitably scaled, sited and designed. I think that must have been what was in the author's mind, and to be in keeping with the character of the area. It's not, I have to say, something that I would be placing great reliance on in any closing submission.
We'll leave it at that.
It's conjunctive with the second part of that policy, which is to consider how it will contribute towards local living and take into account transport needs and so on. So it could form the basis for a long essay about lots of the witnesses' contributions, but I don't think I'm tempted by that.
Next issue was simply about compatibility of the two policy of the two parts of the development plan. Even with section 36, I think I need to understand the development plan as a whole. So I think I would need to apply the test in the development plan, in the Planning Act, for if there's an inconsistency, the later of the two policies prevail. If they're incompatible, the later of the two policies prevail. But my proposal would just be simply, if I consider that there's not going to be an incompatibility, if I consider they come to the same outcome, I will not report on any incompatibility. I think that's the approach to take, is it?
I think that's a fair approach.
Certainly the approach that other reporters have taken with the Highland Wide Local Development Plan and other decisions which have gone either way, then that is a useful practical approach to take.
Okay, Section 8 is a section on climate change, energy security and energy policy and the need for the proposed development. And these are just responding to a number of points raised in primarily Mr. Kelly's statement. So if we just run through them, should the determination of the application be postponed until after the public? I think we can probably take the first two together because they're about future publication of documents by the UK government or by the National Energy System Operator. Essentially, should the application be postponed, the determination be postponed until after those documents have been produced, so that there is guidance on national level?
Our position is no on the first point about the Strategic Spatial Plan for Energy Infrastructure. NESO, that's the National Energy System Operator, is preparing that. It's not likely to be finalised until December 2026. And in terms of the second point, the regional spatial plans, Ofgem's latest position, April this year, is that the first suite of regional plans will not be available until late 2027. That's some 2.5 years from now. So we would say there's no justification to assist this application or any in Scotland until these are published. The Scottish Government's position is that there's need to tackle climate change. That's clear in NPF4 Policy 1. It's not a matter of wait and see what might happen with the regulation of energy. I can say no more than that. Our firm position is that there should not be any hesitation on decision making until these documents are published.
Mr. Campbell.
I don't think it would be credible to argue that you should wait that long for publication of these documents. What's missing in what Mr. Bell's just said, of course, is any identifiable link between this proposal and any measurable impact on climate change. And that's presumably what these plans are going to be directed to. But I'm not going to argue, because I don't think it's credible, that we should wait for the publication of these documents at UK level, which of course have a habit of being delayed.
So the next two questions are more directly on that point. So is the proposed development required to meet policy and statutory targets for reduction in greenhouse gas emissions? And if it's not required to meet those targets, does that indicate consent should be refused? Well, this was from Mr. Kelly's statement, so Mr. Bell first.
Thank you. So I would say in and of itself, this particular development is not required, but as part of a range of projects coming forward that the Scottish Government is requiring, then yes, it is. There are policy objectives and there are statutory targets, certainly in relation to greenhouse gas emission reduction targets, and then we have policy targets in relation to renewable energy generation. This project would make a nationally important contribution. We know that from NPF4, given its scale. The onshore wind statement that we've referred to, page 49, states that deployment of onshore wind is mission critical for meeting climate targets. So that's OWPS, page 49. It sets out the target of 20 gigawatts by 2030. The onshore statement also sets out the legislative context for those statutory targets in relation to the Climate Change Emissions Reduction Targets Scotland Act 2019. We also have within NPF4 the Statement of Need, page 103, and that states additional electricity generation from renewables of scale is fundamental to achieving a net zero economy and supports improved network resilience in rural and island areas. We have a shortfall at present time in relation to the renewable generation target in terms of current installed capacity, and there is also a shortfall in relation to emissions reduction. The latter point was made very clear last year with the Climate Change Committee report stating that Scotland was way off in terms of attaining its 2030 target. Another document which, and just to give you a reference on that, that would be CD 7.8, Climate Change Committee report. But there is one of the relatively recent documents that's been published, referred to earlier, was the UK's 7th carbon budget, CD 7.4. I think it would be useful to just have a look at one page in that. It's the only document I think we need to go to in this session, but it is helpful. And it's on page 109, figure 5.1. And it's a line graph showing.
Just give me the reference again.
So it's in CD 7.4, 7th carbon budget, page 109, figure 5.1, top right, item B. There's various graphs on that figure, but graph B is onshore wind operational capacity, and it's the forecast the Climate Change Committee has made in February of this year in relation to their balanced pathway, which is the recommended approach for the UK government to take. And it shows onshore wind, you can see in the graph, hitting by 2030 about 20 gigawatts, which is in line with the Scottish Government target. Then you'll see the graph extends up to about 38 gigawatts, just below that, by 2050. So it continues to increase beyond the 2030 target. Now, on page 106,
Just hold on, just for, what were you meaning, CD 7.8?
I think it might be 7.0.
Or 7.0?
714.
sorry, my apologies, 714,
What was the page reference?
109.
Top right.
So, top right is graph B, so in the middle column,
So not the right. Middle.
so the top row, middle graph.
Onshore wind operation.
And you can see the horizontal axis has the years and the gigawatt capacity on the vertical axis.
Yeah.
And that's relating to the balanced pathway, which is the recommended pathway for the UK, and it sets out the contribution expected by different technologies. Now, the other reference I think is helpful is page 106, where in relation to onshore wind it states that this will require recent annual installation rates to treble this decade, requiring installation rates comparable to the annual rollout rates previously sustained in the mid-2010s. So, in terms of targets, in the question I would say we have the onshore wind statement, we have the latest carbon budget, and we have the Clean Power Action Plan, which is another document before the inquiry which sets out the UK government's target of 30 gigawatts by 2030.
Can I just ask, the figures and the targets and this are UK targets as opposed to...
In the carbon budget it is, yes.
And right.
So just maybe to finish off Mr. Finley's point, how does that fit together with the Scottish target?
So the figures are different in each. Starting at the Clean Power Action Plan is 30 gigawatts by 2030. That takes into account the Scottish contribution of 20, with the balance, I'm assuming, from England and Wales. And the Climate Change Committee's carbon budget reflects that, but goes further, but a slower rate beyond 2030. And the third document would be the onshore wind statement that has just the Scottish 20 gigawatt figure, which fits with earlier Climate Change Committee advice. So in terms of your question about the targets for renewable energy and specifically onshore wind, I would go to those three documents to look ahead to what is expected for this technology.
Can I ask one question of Mr. Bell? I think you referred earlier to a grid connection date before 2030, but no doubt he can identify where that is in the evidence. But certainly it's Highland Council's experience that, well, obviously it depends when ministers finally make a decision on this case, one way or the other, but assuming they approve it, the time for construction of this wind farm is likely to, certainly on past performance, likely to extend beyond 2030. Now, Highland Council's position, just to be absolutely clear, is that there's no cap, as Mr. Campbell has said. If it's not contributing to the 2030 target, it would contribute to a later target. But the weight you give it, or if it was going to contribute to a 2030 target and was absolutely necessary, then it might have additional weight. But the likelihood of a grid connection, or the turbines being built and connected by 2030 to count towards a 2030 target, we at the very least raise a question mark over. But that is not to, and I absolutely stress this is not to be misunderstood. We're not suggesting that that means there's no significant support from the proposal from our viewpoint or from the government's viewpoint. It's just what target it will contribute to. Because having been at a number of inquiries for the last 2 years, other developers have made the point that proposals in the pipeline are not likely to contribute to the 2030 target. So it's just a realistic approach to contribution.
If I might just add to that, the chapter that's just been referred to in the carbon budget is, of course, we would need to be clear about what status that has. It's headed delivery indicators in the balanced pathway, so it's a prediction or prognostication by the very authoritative committee. Of course, I recognise that. But just be clear what the status is. It seems to me this is a complex matter. It requires probably a rather more detailed submission than one can give you on the hoof this morning. And it needs to be covered carefully, preferably in writing and including submission. I'm dodging the question to some extent, but I think that's a fair way to deal with it.
I would just say, sir, I appreciate Mr. Finley's caveats, but the applicant takes an optimistic view that with the transmission reinforcement now consented and being mobilised, that there's 4 years to the grid connection date. So it's entirely possible for this scheme to be constructed and connect by its August 2029 grid connection date. And that would make a contribution to 2030, but even if it missed 2030, that is not an issue, given that there's a need to sustain renewable generation and the requirements go beyond 2030, as we've seen within those documents.
I suppose the issue would be whether I need certainty or whether the possibility is sufficient for
the weighting of meeting a particular target is not a matter of scientific ascribing of weight. I know Mr. Bell put there is at least a possibility of it contributing to the target. If there was a certainty of it meeting the target, you might give it greater weight. if it's wholly unlikely to meet a target, you might give it somewhat less weight. A possibility, you will give it a weight accordingly. The weighting of factors is not a scientific judgment, it's a matter of planning judgment. So in the light of Mr. Bell's comment, our submission are likely to be that you cannot be certain it will contribute to the 2030 target. The weight you ascribe should reflect that, but it will, I reiterate, it's still a matter that requires weight in the favour of the proposal, because if it doesn't contribute to the 2030 target, it will contribute to something post that, and there is a continuing target. So, but it doesn't get any particular additional weight for meeting a 2030 target, and it's not a debate that Highland Council seeks to get into, but Mr. Kelly's evidence suggests that the 2030 target will be met in any event, so this wind farm is not necessary, in my understanding, in broad terms. Whether that's correct or not, it doesn't take away from our position that you have to have regard to when this is likely to be, and ministers would in due course, so that if some ministers' decisions come out very quickly, some of them don't. If this decision didn't come out till late 2026, it might make it less possible it's going to contribute to 2030. If it came out by late 2025, then one can see that different considerations might apply.
So one final point, I would just say that we've gone to some lengths to set out relatively briefly the international context for the UK's obligations under the Paris Agreement, and that and the more recent UN gap analysis makes it very clear that the earlier a contribution can be made, then the greater the benefits in combating climate change. So it may be the case that you give more weight to an earlier contribution given the urgency of the climate emergency.
The next question is, again, arises from Mr. Kelly's statement, paragraph 40. Are you in a position to speak to that, Mr. Campbell, just now?
No, I'm afraid not.
In that case, I suppose it's a matter for, well, so far as you can, submissions and resting on Mr. Kelly's evidence. I think that, does that apply to F and G there as well?
Yeah.
So the next related question is about grid capacity and energy pricing. So in Policy 11 of the Fourth National Planning Framework, it states that grid capacity should not constrain renewable energy development. It's for developers to agree connections to the grid with the relevant network operator. So there have been a number of submissions to the inquiry, both by Mr. Kelly and by others in the evening session, that the proposed development really displace other existing generation with no net benefit because of the grid constraints. Is that something that ministers can or should take into account?
I think NPF4 policy is clear that it's not to be taken into account in a planning determination, and in this case the grid position is clearer given the reinforcement consent, which is now before the inquiry, and the reference within it to the contracted capacity for it. So the decision for the sky reinforcement is CD 12.32, and that relates to the 110 kilometre upgrade to 132 kilovolts to Fort Augustus, overall 160 kilometres in length. And paragraph 133 of that decision refers to the contracted capacity. So there is a grid solution for the transmission of energy from Skye. Even if there wasn't, I would say that would not be a matter that would be held against the proposed development, given the NPF4 position.
I think that the evidence of Mr. Kelly, and I don't want to mischaracterise it, and also Mr. Klein in the evening session, was that not just about the availability, the grid capacity to take the energy off Skye, but in general that there are constraints throughout the network that constrain the amount of energy that can be generated in the north of Scotland, in Scotland, and further south. I don't necessarily want to go into that. I'm not sure if you're in a position to speak to that, but is that if there are such constraints at the moment, what's the reason for this policy in NPF4? After all, it is only a policy. Ministers can disregard their policy, can they not? If there are such constraints, shouldn't they just disregard their policy?
I think the approach is a long-standing one, has been to get developments consented, and the applicant will then have responsibility for connecting to the grid. And it's been the change at the moment is that grid reform is underway, and there is a new process that parties are entering into, and the broad principle is connect when ready. So I think the government's approach has been, don't complicate land use planning decision making by grid issues, what may or may not happen. Get consent ready, lined up. Some will have connections that can go straight away, others will be slightly delayed. That I think is behind the NPF4 policy position. But what is happening now is that there is a great deal of, Mr. Fitzpatrick will know, within Highland, the accelerated strategic transmission infrastructure applications that are being prepared and will be submitted this year in Highland, and in other parts of Scotland there will be other actions in other licence areas. So a lot of grid investment is underway, but that is separate from the planning determinations, and you see that in all of this post-NPF4 Section 36 decisions. There is no reference in any decision to any grid constraint, perceived or actual.
Of course there isn't, because it doesn't suit Scottish ministers to strike the balance between availability of generation and availability of transmission. That's an awkward political dilemma which you wouldn't expect to see in decision making. That said, this passage in Policy 11 is pretty clear, but it introduces, in my submission, an element of sort of artificiality. You're generating electricity which has nowhere to go because you don't have a grid. And now that's not a matter which a land use planning decision which you have to make can really consider, I don't think. One could argue that they're all part of the same project and they all should be environmentally assessed together, and that salami slicing operates, and there's a whole legal background to that. This is not the time for that. And you'd be glad to hear.
Work plan for submissions, I think, yeah.
The final point I'll just make quickly on that is there clearly is a contracted grid connection here as well, and the existing wind farm has never been constrained off. So that's the factual position for the applicant in terms of grid going forward. That contracted date.
Never been constrained off.
That's my understanding.
No. There was one other question in this section, which is that there were various matters raised about the possibility of changes in the UK system for pricing electricity and the effects it might have on electricity demand in determining the application. And again, that seems to me to be beyond the scope of what can be dealt with in a planning application. Possible future changes in the UK pricing system.
These changes are in train at the moment and evolving very slowly. But what this is a reference to, I think, is locational marginal pricing or zonal pricing for electricity delivered to consumers. It's not one for you with respect. But there's enough to say about this case, both for it and against it, without getting into matters of UK policy, because even if the answer were wholly negative as far as the applicants are concerned, it needn't influence your decision or minister's decision, I don't think. It's just my view at the moment, but to start discussing the reform of the electricity pricing system in this inquiry would be, in my view, an error.
So we do need to give a position on that. That is in Mr. Kelly's evidence. It's before you.
I've just said what I'm going to deal with. How I'm going to deal with it. So,
just some brief points on that. The review of electricity market arrangements is ongoing. That will require future legislation. The view is that it may not come in until the mid-2030s. For ministers to take into account that at the moment would just lead to delay and negatively impact investor certainty and would negatively impact on renewables deployment. So I would agree it's not for you to take into account for those reasons. Thanks.
Next point is about, raised by the applicant, is the applicant's proposed, well, there's the option of 180 metre turbines. And there's two questions there. How would imposing a maximum tip height of 180 metres change the energy yield of the proposed development? And what would the installed capacity of the development be? And would it still be over 50 megawatts?
So I can cut in here because I don't think there's disagreement. In the light of the evidence that's been given, no one suggested a difference between 180 and 200 metres in terms of the impacts on landscape and visual or cultural heritage. So that I certainly couldn't, on behalf of Highland Council, suggest that you should, if you are going to consent to the wind farm, you shouldn't consent the 200 metre version rather than the 180 metre version. There's no logical basis in the evidence for you doing so. There is a complete measure of agreement, certainly with, and I believe it's with all three parties, that in terms of landscape and visual and cultural heritage, there is no material or significant difference between 180 and 200 metres, so that you should, it would be illogical not to go for the more productive scheme. You may disagree with that evidential basis, but that's why I thought it might assist if I told you what Highland Council's position on that is at this stage. I think it must logically follow that from what we've said and where we are in agreement with the applicants.
So that rolls up that point, Mr. Valder.
Thanks, sir. I think the position of the applicant is that there would be a reduction in energy yield up to 9% with the lower tip height. Calculations have been done on that. I think what's helpful may be helpful for you is in the Bargour decision, paragraph 77. I can take it quite briefly, but the ministers discussed there whether design changes would be merited in that case, and they comment that the changes would decrease the average energy production, which would make a lesser contribution to targets. And I think one important point in the onshore wind statement is about route to market. That the ministers have made it very clear that there needs to be a competitive route to market through contracts for difference, and is one measure. So Scottish projects have got to compete, and therefore maximising the benefits is important, not just for the wider public benefit, but for the ability to secure route to market. And so the point I'm making is that in Bargour, that has been a consideration of the ministers in terms of the actual energy output, and whether changes would be justified that might decrease that.
So the other point was just a question of fact about if you reduced the tip height to 180 metres with the battery storage, even if the wind energy fell below 50 megawatts. Is it 59 at the moment? Yeah, so even if the wind energy generated fell below 50 megawatts, it would remain in total above 50 megawatts.
Depending on the candidate turbine. So yes, it could remain at the same level. But if my understanding is that the likely turbine that would be selected would have a slightly reduced overall capacity of 54 megawatts. So it stays at 200, it's 59.4. If it goes down, it could well be 54.
Next point was about the island location. This point raised by Mr MacLeod. So I want to know what duties, if any, ministers have under the Island Scotland Act as regards to termination of the application.
Yes, it was a little surprising to us to see that the Highland Council hadn't dwelt a little bit on the National Islands Plan, which emanates from the 2016 Act. A variety of duties are imposed on local authorities and on the providers of infrastructure so far as island communities are concerned. This is best dealt with in submission. I'm sorry to duck it again, but it's not complicated. It needn't be long, but it does require you to take it into account.
I would agree, there is a duty under section 7.1 that a relevant authority must have regard to island communities in carrying out its functions. Scottish ministers are a relevant authority under the schedule to the Act. That is, I don't think any other significant parts of the Act are directly relevant, and I don't think you're given much assistance as to what you must do in having regard, but you must have regard. So, in a sense, it may bear out on the particular factors that have been put before you in the last two hearing sessions, that those are the type of factors that you are particularly enjoined to have regard to. But it doesn't, in our submission, do more than that.
Yes, I'm sorry, I should say that. It's a duty to have regard to, it's not a duty to do something. Yeah.
So just to make clear the applicant's position, I would agree with that approach.
Next issue is about the grid connection. This is perhaps whether the grid connection for the proposed development forms part of the project and therefore should have been subject to environmental impact assessment with it. The number of legal issues, I'm not sure Mr Bell's in an opportunity to respond to that, or I don't know if Ms Wilson has an opportunity to look at that.
Yes, so I was involved in the preparation of the response that went to your office when this was first raised by the submission that my man friend put in a few weeks ago, if not a couple of months ago. So insofar as it requires to be addressed, it will be addressed in the closing submission.
Yeah, well, I will respond accordingly. When the submission is in, the argument is there, you can see what it is, and it's for you in the end whether it applies or not.
So before we leave this point, can I ask of the applicants a couple of factual questions which may be relevant to this, because I think certainly Highland Council's position, and there's a case going before the Court of Session unrelated to Highland Council, raising this general issue, is that in general terms grid connection is inherent within a proposal, and you will note that, and it's perhaps a matter that you should have regard to, that in the economic impact assessment section of the EIA, you're being asked to have regard to the financial consequences of the grid connection. I think it's some £2 million or something, and the jobs that would arise therefrom. So you are being asked to take, on the one hand, take into account the grid connection, but you have no idea, so the benefits of it, you have no idea of the disbenefits. But this is a repowering, and in a practical sense, there's clearly a grid connection existing. Highland Council's considered the view of whether there's a cumulative impact with the recently permitted main line, if I can call it that, and we don't think there is. So, landscape and visual impact with the main line, which is of course the main point. So given that EIAs are meant to be practical, it does seem, when looking at the grid connection costings, very little money is due to be spent on Sky. I think some £200,000 worth, which frankly is not a significant sum. So it would appear to us that not much significant work is contemplated on the ground. If that, it would help us in responding to your point here to have some confirmation from the appellant as to what is proposed by way of what may need to be additional grid connection for this scheme, because it may not be an issue that arises because there clearly is an existing grid connection. Whether now or that may feature as part of the forthcoming response, it would be useful to have an answer to that, because it may not be a practical issue in this case.
So at the moment, the grid connection route would be to Dunvegan substation. There's already a cable that connects the wind farm to it. There would need to be another cable. At the moment, we can't say whether that would be overhead or underground. That would be for the network operator to decide. And they would screen that if necessary and progress an EIA if it was screened in.
Give warning that in our submission, the current cable's underground, is it? Or is it overground?
Yes.
If there was to be an overground cable, then that is exactly the type of impact that should be assessed as part of the overall proposal, and it would be salami slicing to deal with it separately and later.
Yeah.
Dare I ask, why is it salami slicing? It's different project?
The project, in EIA terms, you're looking at the definition of the project. And I don't think it's I can put this in greater detail if necessary. There are some Irish cases dealing with the same underlying European directive, which, although we've had Brexit, is still applicable, through the EIA regulations, which say that a grid connection is clearly part of the same project as the wind farm for all sorts of practical reasons. And indeed, the fact that in this case you're being asked to take into account the benefits of the grid connection underscore that point. There would be no benefits without a grid connection of any type. There would be no benefits to the environment. As a matter of logic and applying, and I will refer you to the relevant English case law on this, which doesn't deal with wind farms, but applying the criteria that you need to look at as to whether something is part and parcel of the same project, it would be quite difficult to determine that a grid connection is not parcel of the same project as a wind farm. Save in circumstances, one can imagine circumstances you have if the grid connection, if there was a power line running through the site where the wind farm was proposed and the grid connection was simply attaching to it, there would be practically no implications. But otherwise, it's difficult to imagine a project, a more classic example of splitting a project into one part being useless without the other.
So if I could...
But that's a matter I will put in submissions, and my own friend will have the opportunity to respond to. But that's why I asked the practical question, because at the moment it's not, until Mr. Bell told us what he told us, it's not clear if it was going to be another underground cable on the same route as the existing underground cable. That's highly unlikely to have any implications as far as Highland Council are concerned.
Just before Ms Wilson responds, perhaps to follow the logic through, if the form of the connection is unknown, and if it does form part of the project, then what ought to be assessed as a realistic worst case, so it would have to be an overhead line that would be assessed. Is that? Well, perhaps Ms Wilson can respond. Or
I can confirm that in terms of an EIA assessment, you are looking at worst case, and that would appear to be the worst case. It's not a point that I accept that Highland Council has taken on the grid connection so far, but you've asked the question, and having looked at the economic benefit section, socio-economic benefit section, where grid connection is claimed as an advantage, it seems to us that you have to have the rough and the smooth together.
Well, although not raised by the council, it was firmly raised by the objectors. So, yeah. So, Ms Wilson, if you've got a response now, that's fine.
And then broad principle response regarding the principle of salami slicing, but in relation to the specific argument as regards the grid connection for this proposed development. My line of friends' points are based very much upon speculation as to how this is going to be achieved, and that requires some certainty before it can be looked at from a legal perspective. Speculating as to what issues may be raised is very fact-dependent so far as this issue is concerned. Separately, on salami slicing, the case law, as I understand it, is where a tactic is adopted by a developer for the purpose primarily of avoiding obligations under the EIA regulations, where projects are split into different components for the purposes of avoiding the obligations, and therefore no EIA statement is produced. We're not in that situation here at all. There is already an EIA report so far as the wind farm development is concerned. Whether or not there's any separate requirement for EIA depends upon the nature of the development, because a cable wouldn't give rise to such a requirement. So, for all of those reasons, it should probably be dealt with in submission once the applicant has had the opportunity to consider what submissions are put in either on behalf of the council or on behalf of SWIG.
I suppose the only thing that arises from that is perhaps salami slicing is the wrong term for it, because as you say, that's a kind of avoidance situation where you're avoiding doing EIA by splitting a project into different parts. But I think what the submission is actually getting at is that all of the significant effects of the development haven't been assessed, which is a requirement of EIA. So I think, let's say that the grid connection does form part of the project, then the effects of the grid connection, of an overhead line grid connection, haven't been assessed. I think that's the point they're actually getting at, rather than the salami slicing point. Is the way I understand it.
Yes, and I understand that would be relevant, which is why I said we have to have a clear factual basis upon which any legal submission is made, and that's not something I can do today.
wasn't asking you to. No. I think this is definitely a matter for submission, but it's good to draw the points out. Yeah.
I respectfully agree with Ms Wilson. We need a clear factual basis. I'm not sure we necessarily have that on this side of the room at the moment, and we've had what Mr. Bell has said, but don't wish to tie Mr. Bell or the applicant to that. So it'd be useful if there's going to be any update on the factual basis to have that before we make our final legal submissions. Just so that, because once we've put our submissions in, then the applicant will respond to those, and that will be the final word. But we need to be able to make our submissions on a proper understanding as to what the factual basis is.
So the point I made earlier was I think that if you were assessing grid connection as part of So the point I made earlier was simply that if you were assessing grid connection as part of the project, then presumably you would take a worst case and assume that there was no red line, even without a factual basis. Obviously that's a matter for submissions, but that's the way. I'm just giving you that's the way I would understand it at the moment, without the benefit of submissions.
Yes, as a principle of EIA assessment, that is the normal approach, but as I understand it, practitioners adopt that approach where there is uncertainty in relation to the factual matrix, i.e. whether something might be a greater height than it could be. Once I've got certainty in relation to the factual matrix that we're addressing, then so far as Wright Johnson Mackenzie are concerned, they will no doubt be in communication with your office, intimating to the other parties what that factual situation is. And then all parties can address it in law, because I completely recognise it's not going to be of assistance to you to get legal submissions that are on different factual bases.
So just in terms of discussions, if the parties discuss that between themselves, and then if you come to agreement to provide it to me. So a few more points. The issue of fire safety is raised by Mr. Kelly in paragraphs 26 to 36 of his statement, and particularly in relation to battery storage. Is that an issue I can address? How should I address it?
Well, Mr. Kelly set out very clearly under the heading of community safety concerns what I respectfully submit are legitimate planning issues, which you should consider. And it'll be for you to weigh whether the risk is real or imagined or somewhere in between. I'm not sure that I need to add anything to what he has actually said in terms of the evidential foundation for this. We're not asking you to assume there will be a fire which will destroy woodland or moorland on Skye. We're asking you to recognise that there is a risk. And if you require further information, for example, from the Scottish Fire and Rescue Service, it's open to you to recommend to ministers that they require that consultation before they grant consent, if that's the way they're minded to proceed. I think, without repeating what you see in 26 to 36 of Mr. Kelly's submission, it's set out quite well there, if I may say so, and you don't need me to add to it. This is a recognised but rare risk of this type of installation. Where it has occurred, the impact has been very serious indeed. But I'm not giving evidence, you understand. I'm making a submission, I'm not giving evidence about that.
So I'm seeing this, Mr. Finlay.
Yes, it's just to alert you to the fact that this is a contentious condition. We're suggesting there should be conditions to deal with fire risk, put broadly. It's contentious between us and the other side, but that's how we, just to alert you to the fact that that would come up for the condition session, whenever that will be.
Thanks, sir. I think firstly it's helpful that Mr. Kelly actually says at paragraph 27 of this statement that it is the law that the operation of planning and consenting regime should not seek to replicate or duplicate other regulatory regimes. So I would agree with that. And battery systems are a fast evolving technology, but it is a technology that's fully supported in MPF4 for encouragement and deployment. And I referenced earlier the onshore wind statement, which flagged the opportunity for, in particular, repowering projects to accommodate it. Any developer would need to comply with the Construction Design and Management, it's the CDM regulations 2015. It's also the Fire Safety Scotland Amendment regulations. Battery design contains a range of safety systems from automatic shut-off, fire suppression, remote management and controls, deflagration, venting, and are subject to site safety audits every year under separate legislation. The Scottish Ministers have been consistent in their position that it's not a material planning matter. That's also my experience with the majority of planning authorities. Some take a different view, but we anticipated this issue may arise, and CD 12.27 is a Scottish Minister's decision which I think is helpful in setting out their position in relation to fire risk and fire safety. They reference non-planning controls and take the view that the condition that was sought in that case would not meet the tests in Circular 498 on planning conditions. And that would be the applicant's position here.
But I understand we'll return to this in the conditions session then, right? I've got item 14, any other matters of policy interpretation or application parties wish to raise, and I actually raised one previously in relation to, well, Mr. Finlay put it up, under the banner of precedent, I think you said. So I don't want to mischaracterise Ms. Anderson's evidence, but this is the way I understood it, that landscape and visual, that once the proposed development is present in the landscape, it would mean that other proposed developments, such as Glenwillinish 2, would have less of a landscape and visual impact. Is that a consideration for ministers in determining the applications? This application. Obviously, just to give a bit of context, I'm just thinking about writing my report for ministers who have a number of applications before them in Northern Skye anyway, even though I'm only giving a recommendation on this particular development. So what I'm thinking about is whether the additional cumulative effects of this development should be the main consideration for me in reaching my recommendations, or are the combined cumulative effects an important consideration, and if so, how should I take them into account?
I think first from a planning perspective, what may or may not happen with other applications shouldn't have a bearing, I would say, on this determination, in that we know, I think all of us, that an application should be determined on its merits, not what may happen with other projects that may have a different visual relationship with a scheme. I think it was the point raised in the landscape evidence that if there are turbines in the landscape, it may make the sensitivity less so. But in this case, I would say this is a repowering scheme. There are already turbines at this location. There is a characterising effect. The impacts that have been identified are largely localised. And then you've got the grid points to bring in, and we've talked about the urgency of deployment today. So I wouldn't place weight on the precedent point, and the other applications are certainly some distance away in terms of the procedures of gaining consent, potentially gaining consent or being refused. And also 200 metres was new, maybe new for Sky, is not new for Scotland. It's not a new matter that is 200 metres is breaching. The tallest turbine in Scotland is 251 metres onshore consented. And there are others between 200 and 251. So I would say it shouldn't be a matter that should attract any significant weight.
To ask a question during the week, I forget of whom, about whether there were existing 200 metres in turbines in existence.
I don't think I asked that, but I think it was asked.
Just for your information, there are on Kite Muir, which is in South Lanarkshire, KYPE. If you found yourself there at the weekend, you would see them.
Okay, well, I might go down and have a look at that, yes.
There are others, sir. It was also Mr. Finlay's question, I think, in chief to Mr.
He said that there were, and I'm sure it was Kite Muir that he was referring to.
I thought he said there weren't any.
Not in Highland, but there were some that over 200 metres. He definitely said there was one over 200 metres south of Edinburgh. And I'm sure that's what he was referring to.
I've got the information on that, if it's helpful. There are two schemes in operation at 200 metres. It's, as Mr. Campbell correctly says, Kite Muir Extension, 8 at 200 metres. It came up.
If you drive onto the site, you'll get thrown off by burly men.
Came operation
I've had the experience. You need permission.
The second one that Mr. Finlay's referred to is Long Hill Burn. Long Hill is one word. Then Burn in West Lothian, 8 turbines at 200 metres, became operational in 2023. And just for information, since NPF4 came into play in February 2023, there's several schemes consented at 200 metres and 235 and 251. I can give you the names if that's helpful. Yes. So, Southkirk 2 consented in August 23, 42 turbines at 200 metres. Cleansaid, which is CHLEANSAID, Highland, consented December 23, 16 turbines at 200 metres. Thirdly, Rowan, that's ROWAN, Argyll Butte, consented April 24, 13 turbines at 200 metres. Fourth one, Lethans Extension, that's LETHANS, East Ayrshire Council, consented August 24, 10 turbines at 235 and 251 metres to tip. Next one is Clachaig Glen, CLACHAIG Glen, November 24, consented 12 at 200 metres. Second last one is Strathoical. I will caveat it's subject to a legal challenge, but consented January 2025, 11 turbines at 200 metres. And lastly, Mid-Moyle, that's spelled MOILE, January 2025 consented 14 turbines at 200 metres. And I've forgotten what council area Mid-Moyle is in, but so there's seven schemes.
One of those, at least, was Mr. Fitzpatrick's that he'd referred to in his evidence as having been the officer concerned. Cleansaid.
Yeah, that was the case.
I can't remember. Did you come back on the issue of precedent or the issue of...
I think that I'm not sure precedent. It's a matter I'm going to deal with in submissions, but in short form, short precedent is perhaps in planning an emotive word, but the alteration to the baseline that would occur if you introduce 200-metre turbines may well be a relevant factor for the ministers to consider. I don't think I'll say more than that at this stage, but we will touch on that in our closing submissions.
Just to note that, as I understand it in methodologies, that it's a matter of sensitivity, susceptibility of the landscape and sensitivity of the landscape for landscape considerations, and it's a matter for the magnitude of change in the visual assessment. If that helps.
Well, I think I understood Mr. Bell to correct my clumsy question as well, so thank you. And so the last question in the session is essentially to give parties an opportunity to set out their views on the overall balance. Now, obviously, there's a matter that will be dealt with in submissions, but if parties want to say something now, then this is the opportunity to do it. So essentially there's 2 points, the overall balance in terms of Highland-wide local development plan policy 67, and in terms of the overall balance that ministers should strike on determining the application. So I'll look at Mr. Bell first.
Thanks, sir. I would say on policy 67, the key term in that policy is no significant detrimental impact, and our position would be that there are no impacts arising that would be so significantly detrimental that the project was unacceptable. We've examined the position of localised impacts. You will make a judgment on that. Our position is that the landscape and visual impacts would be largely localised. In NPF4, that means that they're generally acceptable. You then need to look, are there any receptors that would be so affected that the project is unacceptable? We haven't identified any that would be. There are no significant effects in relation to national landscapes or national parks. The onshore wind statement is clear that there will be a requirement for taller turbines. We've seen through the list just referred to that there is a trend that we discussed earlier in the week of taller turbines. This is by no means the tallest, and it's fairly standard now. We've got Highland Council has raised no objections to 2 other schemes of 200 metres, so it's not new for the Council to deal with. We would say there's been appropriate design mitigation that's been laid out in the process of the scheme evolution set out within the EIA report. There are no objections from consultees, principal consultees. The Sky Reinforcement project has been consented. We've talked about the grid connection and the early contribution the nationally important development could make. And I think at the end of the day, it's a relatively modestly scaled project in the scheme of what is coming forward elsewhere in Scotland, not just on Skye. And the repowering aspects are important. And we referred to some of the references in the onshore statement, and I think that's an important material consideration, given there is existing infrastructure and sunk investment in the project. And I think these are probably the main points I would highlight in conclusion. Thank you.
We'll deal with it in closing submissions, but I should just perhaps lay down a marker that we certainly don't accept that this is a modest proposal in its context.
Mr. Campbell.
Mr. Bell's covered those aspects of the development which obviously favour a consent, but for you to go along with what he said depends on the factual conclusions you draw, and that's clearly where we're at odds. And that will be the foundation of how you strike the planning balance. Interestingly, this is a case where Section 36's duties to have regard to do not apply, because Mr. Bell's client is not a holder of a generation licence. So the duties lie on the ministers instead of on the developer. I don't want to go beyond that just now. I don't have nothing else to add.
Well, normally the applicant would get an opportunity to sum up. Is there anything you want to respond to there, or to have the final word? Is there anything you want to respond to?
No, sir, that's fine, thank you.
In that case, that draws the inquiry, well, this part of the inquiry to a close. We do have two more sections, one on conditions and one on ornithology. We'll finalise, Wednesday afternoon has been suggested for the conditions session, the ornithology session, at a date to be arranged in August. So I think all that remains to do is for me to, well, the applicant will check those dates and times for Wednesday, and then I can say thank you very much to everyone who's taken part. It's been extremely useful to me, well, thank you, and I can now release you. Thank you.
Thank you, sir.
Yes, thank you. Can I say, I think on behalf of, I'm sure on behalf of all of us, we're most grateful for the way you've conducted this inquiry. It's been very gentle in a way, but thorough, persuasive. Thank you.